Well, good afternoon. If you are just newly arrived, the morning panel was one not to have missed. Although I understand there are already excerpts on YouTube, or so urban legend perhaps, but maybe not. Anyway, I'm David Gregory, and one of the co-hosts of this extravaganza with Leonard Baines. The panel coming up now is in many ways the most important because it's what academic folks do. We talk, we think, we write, and write some more. We had quite an engaging evening yesterday, and it was more lively than most full-blown conferences are. So if that was a preview of coming attractions, everybody in the room is in for a treat. The question then, who to moderate? And so, the best first name I've heard in years, Special Hagen. She is a plaintiff employment rights lawyer, obviously deep connections into the churches, and very bright, University of Southern California, University of Pennsylvania Law School. And I think the best is yet to come, both in the panel today. This sort of, nobody knows it yet, but auditions for the faculty. It'll be a step down, but you'll still have a blast. So without further ado, Special Hagen and the assembly. Thank you.
I want to start off by thanking Professor Gregory for inviting me and the rest of the panelists here today. It's truly an honor for me to moderate this afternoon's panel. Title VII really has opened the doors, I can say, speaking for myself, for me and for many of us in this room. And, you know, today, as a beneficiary of Title VII, I think that, you know, it's our obligation not only just to have the door open, but to actually walk through that door, to perform, and to stay there. I guess it's an issue with retention, especially when you're looking at the workplace specifically. And this afternoon's panel really examined some of the shortcomings of Title VII as we know it today. And not only do we examine some of the shortcomings, but we also look at solutions and how to deal with workplace discrimination and moving forward. So without further ado, I'd like to, I guess, introduce our panelists to the extent of their work and, you know, just some of the issues and topics that they will be touching on during the course of our discussion this afternoon. Firstly, we first have speaking Associate Professor of Law at the Thomas Jefferson School of Law, Rebecca K. Lee. Professor Lee will discuss her paper, The Implications of Fisher versus University of Texas on Workplace Affirmative Action. Professor Lee will examine how the law has been developed in the area of discrimination in the academic setting and how that can be applied in the workplace. We then will have Professor Natasha Martin, Associate Dean for Research and Faculty Development at the Seattle University School of Law, and her paper entitled Echoes of Jim Crow in the Contemporary Workplace. She'll basically examine how racism has morphed and evolved as we know it today from the 60s and 70s to how it manifests itself today in the workplace. Next, we'll have Professor Kimani Pauli-Mill from the Fordham University School of Law, and she will discuss her paper Beyond Title VII, Rethinking Race, Ex-Offender Status, and Employment Discrimination in the Information Age. Her paper examines a number of questions, particularly how does what appears to be facially neutral job requirements result in a disparate impact on African Americans and Latinos in the workforce, as it pertains particularly to prior convictions and the use of search engines to conduct employee background checks. Next we'll also have Associate Professor of Law, Sahar Aziz. She will discuss her paper, Veiled Discrimination, Coercive Assimilation in the Workplace. Her work examines the biases Muslim women in the workplace encounter, particularly post 9/11. The topic touches on the intersectionality of protected statuses. And next we have radio host and multimedia journalist and human rights activist Kathleen Wells. She'll discuss two cases that I guess illustrate the shortcomings of the law. Rowe Entertainment et al. Versus the William Morris Agency, and Washington versus William Morris Endeavor. Lastly, but of course not least, is Assistant Dean of Dispute Resolution Programs and Professor of Legal Practice, Elaine Greenberg. She will present her paper, An Amnesty Approach to the Implicit Bias in Isms and Mediation Design. Professor Greenberg will, I guess, look at how the law falls short of examining implicit biases and implicit discrimination, and is really, I guess, lacking to the extent that it leans toward explicit discrimination, which is usually not the case in today's workforce. So please, without further ado, please join me in welcoming today's panelists. First up, we have Professor Lee. I think you will be speaking first.
Great. Welcome to all, and thank you to Special Hagen for moderating our panel and introducing all of us. So I am Rebecca Lee, and I'll be speaking about the Supreme Court's 2013 decision in Fisher versus University of Texas at Austin, which raises interesting questions about its relevance for employment law and what employers may be able to do, both public, and I think there's a message for private employers possibly as well, what employers may be able to do to achieve employee diversity in the workplace. So while Fisher raises some interesting questions that I'll be exploring, let me also first say that Fisher settles an important question by confirming that the Supreme Court's earlier holdings in Regents of the University of California v. Bakke, Greta versus Bollinger, and Gratz versus Bollinger are still good law. Thus, in the higher education context, and that's the context in which these cases arose, it remains unchanged that a university's interest in attaining a diverse student body for educational purposes is a compelling state interest that can make the consideration of race in university admissions constitutionally permissible under the 14th Amendment's Equal Protection Clause. Fisher does not limit the use of race in affirmative action programs per se by public universities, and may not limit the use of race in affirmative action programs by public employers either. But in taking a closer look at the narrowly tailored part of the strict scrutiny standard under the Equal Protection Clause, Fisher, I believe, clarifies that this is for the courts to fully and independently assess. And in providing this clarification, Fisher may provide further guidance to public employers who engage in affirmative action efforts, guidance that may also be applicable to private employers on this issue. So Fisher discusses Bakke and explains that the decisions of public actors, such as state universities and public employers, they're all state actors, if their decisions are based on race or ethnic origin, that their decisions must meet the requirements of the Constitution's 14th Amendment. Any race-based decision or action must satisfy strict scrutiny, requiring that the decision serve a compelling governmental interest and is narrowly tailored to meet this goal. Fisher looked at the particular context of higher education and affirmed that a state university has a compelling state interest in the educational benefits that flow from a diverse student body that could justify the use of race in university admissions. In doing so, Fisher, along with the Bakke and Greta decisions it cites, provides some support to argue that the benefits of diversity may also be recognized as a compelling state interest in the public employment context. Now, although a public employer does not have an educational mission, employers nonetheless have an interest in the business and organizational benefits that flow from a diverse workforce. Consider the amicus briefs relied on by the Supreme Court in Greta, arguments put forth by employers and corporations who argued that the modern global economy requires leadership skills that rely on, quote, exposure to widely diverse people, cultures, ideas, and viewpoints, end quote. The Amity recognized that broad exposure to people from different backgrounds furthers the diversity interest not just at school, but also in the workforce. Since Fisher affirms Grutter and builds on it, a public employer may be able to show that it has a compelling state interest in the benefits that flow from a diverse workforce that could justify their use of race in the employer's hiring or selection process. Public employers, however, admittedly, would not be able to claim that their mission is to educate their employees or to have them engage in learning discussions. But if an employer's business judgment is that diversity is essential to its institutional mission, then this ought to receive some judicial deference, just as a university's academic judgment that diversity is essential to the educational mission receives some judicial deference. And the Fisher Court did state that the strict scrutiny standard used in the higher education setting would apply in other contexts. And so this would likely apply in the workplace situation as well, the strict scrutiny standard. If the goal of attaining workforce diversity may be deemed to be a compelling state interest, then a reviewing court would need to independently assess whether the employer's hiring or selection process is narrowly tailored to meet this asserted goal, as explained and clarified in Fisher. That is, a court would need to examine whether an employer's hiring process is individualized and flexible so that it considers the applicant's race or ethnicity as one factor out of many relevant factors. The court must also determine whether the employer could have feasibly implemented an alternative hiring or selection process without the use of race. If a public employer were to receive deference by the courts as to whether it has a compelling interest in having workforce diversity, then it seems that the employer should not necessarily also receive deference on whether its hiring or selection process is narrowly tailored to meet this goal. That is, to meet strict scrutiny's narrow tailoring requirement, an employer would have to present sufficient evidence to demonstrate its need for a hiring process that takes into account race. Requiring independent judicial assessment as part of the constitutional inquiry provides a procedural safeguard when reviewing governmental action under strict scrutiny. So separate and complete judicial review and process, it seems, is needed even when the state program at issue appears to have been well considered and implemented in good faith. Therefore, under this constitutional standard, a public employer may be able to pursue its diversity-related workplace goals if it could present sufficient evidence to allow a reviewing court to separately evaluate whether the public employer's hiring or selection process is narrowly cabined to achieve the workplace and business benefits of diversity. Now, how about private employers? As for a private employer's use of race as part of a voluntary affirmative action plan, this would be governed by Title VII. Title VII also governs public employers as well. And we have the Supreme Court's cases in United Steelworkers versus Weber and Johnson versus Santa Clara Transportation Agency that govern this question under Title VII. We know that the statutory language of Title VII does not prohibit all private, voluntary, affirmative action efforts. On the contrary, it allows voluntary affirmative efforts to address racial or gender imbalances within certain parameters. In enacting Title VII, we ought to keep in mind that Congress sought to avoid unnecessary federal regulation of private businesses. Title VII was enacted pursuant to the Commerce Power to regulate private actors and was not intended to incorporate the requirements of the 14th Amendment. Title VII thus has been interpreted to allow for an employer's exercise of business judgment in meeting the statute's anti-discrimination goals. If an employer's business judgment is that diversity is essential to its institutional mission, then this should receive some judicial deference under Title VII. Now, although business necessity cannot be used as a defense to a charge of intentional discrimination, asserting the existence of a valid employer affirmative action plan is actually not an affirmative defense, but simply does not amount to action that violates Title VII. For an affirmative action plan to be permissible then under the statute, the plan must be designed, as we know from Weber and Johnson, it must be designed to break down old patterns of racial and gender segregation and hierarchy, structured to create employment opportunities for protected groups in traditionally segregated job categories. The plan cannot unnecessarily trammel the rights of white or male employees or create an absolute bar to their advancement. The plan also must be temporary. That is, it must be intended to eliminate manifest racial or gender imbalance, but not intended to maintain a racial or gender balance. As the Supreme Court noted in Johnson, under either Title VII or the Constitution, the petitioner bears the burden of establishing that the employer's affirmative action plan is invalid. But Title VII takes a more flexible approach to affirmative action than does the Constitution. Further, Title VII was amended by the 1991 Civil Rights Act, which added Section 116, the only amendment expressly referring to affirmative action. Section 116 reads, and in short, quote, "Nothing in the amendments made by this title shall be construed to affect court-ordered remedies, affirmative action, or conciliation agreements that are in accordance with the law," end quote. The language in Section 116 then states, in essence, that nothing in the 1991 Act affects affirmative action that is in accordance with the law. And since Congress did not modify or reject the Supreme Court's rulings in Weber and Johnson, then Section 116 appears to preserve the legal force of those cases and say that nothing in the 1991 Act affects affirmative action that is in accordance with Weber and Johnson. But moving forward, to the extent that the Supreme Court's approach to affirmative action under Title VII becomes stricter post-Fisher, public and private employers who wish to implement race and gender-conscious affirmative action plans for hiring and promotion decisions, it seems would be well advised to model their selection processes after those not just in Weber and Johnson, but also follow the model in Grutter and be prepared to present sufficient evidence to satisfy the standards, the strict scrutiny standard also found in Fisher. The Supreme Court's recent decision in Fisher permits affirmative action based on race, as we know, in the university setting, subject, that is, to full and complete judicial review. The permissibility of such efforts should extend to the public workplace setting under the Constitution. Private employers can still look to Weber and Johnson, still good law, in proceeding with their affirmative action programs, while also heeding the evidentiary requirements needed for strict scrutiny to further bolster their use of race as well. We have to hear your comments and questions. Presentation, thank you.
We're now going to go to Professor Holly Neal and her presentation.
Natasha was next, I think, in the lineup, correct? All right, good morning. My presentation deals with an issue that Chair Varian discussed earlier this morning during her talk, which is Title VII and the use of criminal records in employment. This is based on an article that will appear later this spring in the Virginia Law Review. So obtaining someone's criminal history information is one of the easiest things you can do online today. All you need is a computer, a valid credit card, someone's name and social security number, and a couple minutes to spare, and you're off to the races. And this will give you virtually instant access to the more than 93 million computerized records available online today. And just a few decades ago, background checks for employment were difficult to conduct. And this is because you'd have to know which courts or government agencies to visit to find relevant documents. And if you suspected that a person might have records in multiple states, you might have to go and actually visit each one. As a result, background checks were relatively rare and were reserved for people in sensitive and high-ranking positions. But today, tens of millions of criminal history searches are conducted each year through companies in the multi-billion-dollar background search industry. And you're probably familiar with some of these companies, LexisNexis and HireRight, to name just two. And among those most likely to conduct searches are employers. Now, getting a job in this economic climate is tough, but it's even tougher for people with criminal records. That's because today, over 90% of employers, including Walmart, the nation's largest private employer, conduct background searches. And nearly 3/4 of employers have adopted broad prohibitions on the hiring of people with criminal records. And these companies include Bank of America, Domino's Pizza, Lowe's, and many even bar the hiring of people with just an arrest. And this affects a lot of people. Nearly 1 in 3 individuals in the US has had some involvement with the criminal justice system that would turn up during a routine background search. And in raw numbers, that's 65 million people. The overwhelming majority of their offenses are for minor or non-violent offenses, such as curfew, loitering violations, vagrancy, disorderly conduct. And records often consist solely of an arrest that didn't lead to a conviction. Yet this information can be reported in a criminal record and be used to deny an individual a job. And this has a disproportionate impact on people of color because they're overrepresented in the criminal justice system relative to their share of the population and relative to their involvement in criminal activity. So for example, African Americans are up to 15 times more likely to be arrested than whites for low-level offenses, while Latinos are 3 times more likely than whites. And this is due to policing tactics, this is due in part to policing strategies that target minority communities, such as stop and frisk programs, the war on drugs, broken windows policies, which have all become popular among urban police forces. Yet not only are people of color more likely to have a criminal record, but for this group, having a record is significantly worse than for whites. So for example, groundbreaking audit studies conducted by researchers at Harvard and Princeton universities found that whites with a criminal record were half as likely to receive a callback as whites without a record, while blacks with a criminal record were 1/3 as likely to receive a callback as blacks without a criminal record. But most disturbingly, the research also revealed that whites with a purported recent felony conviction had a higher chance of getting a callback than blacks without a record at all. And similar patterns have been found between whites and Latinos. And these findings suggest that people of color are particularly stigmatized by having a record, and in fact suffer what scholars call a criminal records penalty. The fact that employers have virtually unlimited access to criminal history information only intensifies this stigma, making it all but impossible for minorities with criminal records to find gainful employment. In my paper, I propose a framework to address this problem of stigma and discrimination. I call it the health law framework because it borrows from the doctrinal structure and normative commitments of laws from the health law context. And as I'll explain, these laws operate to counter both stigma and discrimination preemptively. Thus, they offer a model that may succeed where current laws have failed in addressing employment discrimination that stems from having a criminal record and being minority status. So, what are the current laws used to address this problem? They're Title VII and the Fair Credit Reporting Act, which I'll refer to as FCRA. But as I'll explain, neither law adequately protects the interests of employers or potential employees, and here's why. I'll start with the FCRA. This is a federal law that governs the collection and distribution of consumer information for employment. And this includes the distribution and of criminal records by background checking companies. Now, the law requires employers to get consent from job applicants before conducting a background search, and to notify applicants if they're denied a job or fired on the basis of the information contained in one of these reports. but the law is inadequately enforced. Employers typically get an application, do an online search without consent, and then never call the applicant if a criminal record is found. And on top of that, the FCRA is supposed to ensure that the information contained in a record is accurate, but it fails to do that too. Numerous studies show that criminal history reports are riddled with errors and frequently contain significant inaccuracies. For example, they often contain misspellings and clerical errors, which can lead to false positive and false negative identifications. And there are other types of errors as well, including the release of sealed or expunged information, or instances of missing case disposition information, such as a felony that was reduced to a misdemeanor, or cases where all the charges were dropped. And it's estimated that hundreds of thousands of these errors occur each year. And this error rate translates into huge numbers of people being denied employment opportunities. And erroneous reports can circulate indefinitely, all the while applicants may never know why they were denied jobs. So that's the FCRA. Then there's Title VII, which, as you know what Title VII does, right? It prohibits discrimination on the basis of race, color, religion, sex, and national origin in employment. But it also prohibits employers from automatically denying people employment based on an arrest or a conviction record. And this is because broad prohibitions on the hiring of people with criminal records are likely to have a disparate impact on ethnic and racial minorities, who are statistically more likely to have a criminal record. However, Title VII, when applied to criminal records discrimination, produces unique difficulties that make it incredibly difficult for people with criminal records to get hired and challenge adverse employment decisions. And this is due to several factors. First, Title VII was created to target race discrimination, but criminal records discrimination is different from race discrimination. So consideration of race in hiring is illegal because race is generally understood to be irrelevant to an employee's ability to perform on the job. Criminal history status, on the other hand, may be quite relevant to hiring. So for example, if an employer is hiring a bank teller or an accountant, if the fact that the candidate might have a recent embezzlement conviction might be quite relevant to the employer. On the other hand, consideration of a loitering conviction might not be relevant to an employer hiring a bus driver, for example. Another problem with Title VII is that although under Title VII, employers can lawfully consider a job applicant's criminal record when making an employment decision, the applicant's race may consciously or unconsciously influence negatively an employer's evaluation of the record. And this makes invidious discrimination very difficult to detect. An additional problem with using Title VII and the FCRA to address this problem, this type of discrimination, is that this discrimination happens early in the hiring process, typically, often before a candidate even meets with an employer. So the candidate often has little explicit knowledge of why he or she was denied an interview or a job, and may in fact never know the true reason for their rejection. And this limits their ability to challenge an employer's discriminatory actions. Finally, neither Title VII nor the FCRA address the ways in which the combination of a criminal record and minority status create a distinctive and powerful social stigma that studies show is significantly more harmful than minority status or ex-offender status alone. For these reasons, neither Title VII nor the FCRA can effectively prevent or redress invidious discrimination in this context. So this brings me to the health law framework, a legal model based on two specific laws, particularly the ADA, the Americans with Disabilities Act, which prohibits discrimination against people with mental or physical disabilities. And the second law is the Genetic Information Non-Discrimination Act, or GINA, which prohibits employment discrimination against people with genetic predisposition to develop disease. I argue that the current FCRA Title VII scheme can be modified and strengthened by incorporating parts of the ADA and GINA, particularly their doctrinal structure and norms, which I suggest would better account for the unique stigma that attaches to dual criminal records and minority status. This is because, first, having a disability, like having a criminal record, is relevant to employment decision-making, and both can be used as a legal ground to exclude individuals from employment. This is never the case with race. Second, in contrast to Title VII and the FCRA, both the ADA and GINA were designed to target discrimination based on a trait or condition that may be invisible, but which carries a powerful social stigma. And third, in the health law context, as in the criminal record setting, employers are allowed to consider potentially stigmatizing information about employees and job candidates. Therefore, the ADA and GINA were designed to regulate the flow of stigmatizing information in order to prevent discrimination preemptively while ensuring equality of opportunity. So how would this work in practice? Under the ADA, an employer can't attempt to learn whether an applicant has a disability prior to making a job offer. This is to ensure that people with disabilities have a fair opportunity to be judged on their qualifications. Then, when an offer has been made, but before the candidate begins work, an employer may ask disability-related questions. However, if an individual is denied a job because questions reveal a disability, then, just like under Title VII, the employer must demonstrate that the exclusion is job-related and consistent with business necessity. Now, as applied to the criminal record setting, employers should be precluded from requesting, acquiring, or purchasing a job applicant's criminal records until after the pre-offer phase. And in keeping with GINA, employers should be precluded from accessing the stigmatizing information from online sources like commercial criminal records databases. Now, this health law framework allows individuals with criminal records to get past the phase at which employers are most likely to exclude candidates based on their stigmatized status. And according to this doctrinal scheme, this doctrinal scheme would make it easier for people with criminal records to prove intentional discrimination because it forces an employer to justify rejecting an applicant after already approving them. In addition, this doctrinal scheme would enhance the FCRA's provisions that require employers to obtain the job candidate's consent prior to conducting a background check, and that mandate notifying an applicant if a report is used to make an adverse employment decision. In so doing, this health law framework would alleviate the problems caused by the pervasive inaccuracies that now plague criminal history reports. It would, for example, give a job seeker a meaningful opportunity to explain or rebut or check the veracity of a record before being disqualified from employment. Moreover, it would also allow job candidates to catch a record that should have been expunged or a felony that was subsequently reduced to a misdemeanor or some other error in the record. Now, employers often say that they don't want to hire people with criminal records because doing so would increase their risk of tort liability from a negligent hiring or negligent retention lawsuit if the employee were to commit a crime at work. Now, in the ADA and GINA context, employers are similarly concerned about increased health care or other costs that may be imposed by hiring someone with a disability or a genetic predisposition to develop disease. Still, the expectation under the ADA and GINA is that the employer will assume the risk. Now, here the ADA's direct threat analysis is instructive. Under the ADA, an employer can refuse to hire an individual if it can show that the person poses a significant risk to health or safety. However, an employer can't refuse to hire an individual, a job candidate, based on a marginally increased risk, speculation about future risk, or assumptions about the disability. An employer must also consider whether a reasonable accommodation could eliminate the risk. If the requested accommodation causes an undue hardship, which is to say, would require substantial difficulty or expense, the employer would still have to provide another accommodation that does not. Hence, the reasonable accommodation mandate is an explicit recognition that the employer is best able to bear the costs associated with employing a disabled applicant. In comparison, in the criminal records context, the assumption for many employers is that people with a record are at a high risk of committing future crimes. But data reveals that once those with criminal records have stayed clean for a few years, their chance of being rearrested for a new crime essentially disappears. And this point is widely referred to as the point of redemption, which averages from between 3 to 7 years, depending on the offense and the age at which the arrest occurred. In addition, studies show that individuals with criminal records are less likely to commit a crime in the workplace than an employee who's never been convicted. Now, this is not to suggest that there are no crimes, there are no risks or costs associated with hiring an individual with a criminal record, which, like all hiring, involves an element of chance. However, employers are better able to assume the costs and risks involved in the hiring process than those who experience criminal records discrimination. Plus, As with the disabled, the costs of failing to facilitate employment for this population are tremendous. Many people with criminal records are the primary earners for their families, so employment discrimination against this population has negative third-party effects. Moreover, people with criminal records who spend time in jail and who are jobless at reentry are 3 times more likely to return to prison. And today, incarceration expenditures cost taxpayers $56 billion annually. Stable work, on the other hand, is among the most effective means of protecting against a return to criminal activity, reducing recidivism by as much as 40%. So although the reasonable accommodation mandate is about the allocation of costs, it's also an explicit recognition that removing employment barriers is a necessary means of reducing social marginalization and ensuring full citizenship. Now, to be sure, having a criminal record is not entirely analogous to being disabled or having a genetic predisposition to develop disease, to the extent that one can be born with a disability while one ostensibly earns a criminal record. But this isn't always the case, particularly for people from minority communities. Indeed, 1/3 of people with criminal records have never been convicted of a crime, as many criminal reports contain only arrests, including those where all the charges were dropped. And such arrests are most likely to occur in minority communities where aggressive policing tactics and indiscriminate arrests are common. So in New York City alone, for example, of the nearly 750,000 people stopped and questioned by the NYPD in 2011, 87% were Black and Latino and 9% were white. Nearly 90% of those who were stopped had done nothing wrong, but such stops may result in an arrest that could be reflected in a criminal history report. And such practices have been found to be quite widespread. One more minute. So for example, in 2012, the New York Civil Liberties Union filed a lawsuit against the NYPD's practice of stopping and ticketing and arresting thousands of individuals for trespassing in their own buildings if they failed to show identification when they went out to check the mail or took out the garbage or ventured into the hallways. So with respect to some offenses, some degree of stigmatization may be appropriate, and every person may not be appropriate for every job. But these individuals should be entitled to a second chance after paying their debt to society. They shouldn't be automatically denied the opportunity to compete for legitimate employment that would enable them to support themselves, pay their taxes, make a positive contribution to their communities and the economy. Moreover, individuals shouldn't suffer a lifetime employment penalty for an unsubstantiated arrest, a youthful indiscretion, a minor infraction, or even a more serious offense that happened in the distant past. Yet this is exactly what's happening. So it's my hope that this proposal will continue the EEOC's bold, I would say, and important efforts to ensure employment opportunities for those with criminal records. Thank you.
Thank you, Professor Paul-Will. Now we're going to have Professor Martin discuss her paper with echoes of Jim Crow and contemporary work. So, thanks.
Well, what will be rolling are just some images that I want you to keep in mind as I move through my comments today. So I'm really honored to be here and to be a part of this panel and this really incredible opportunity to think deeply about the progress that we've made over the last 50 years. And so my presentation will do a couple of things. I want to chronicle the events, certainly that led to the enactment of the statute, and theorize the construction and implicit assumptions that are associated with people of color in the contemporary workplace, to argue that Title VII has not had the transformative impact on inclusion in the American workforce to match the ideals of belonging that were professed at the time of its enactment. This exploration will reflect the symmetry in narratives of incompetence associated with workers of color in the 1960s and earlier, and today to further debunk the myth of inclusion and equal opportunity. So my paper necessarily will highlight deficiencies in the categorical approach to Title VII in the manner in which the courts have interpreted the meaning of discrimination on these bases, including the symbiotic relationship, as I call it, between substantive law under Title VII and procedural law. Highlighting these shortcomings reveals not only the doctrinal deficiencies, but also the normative effect of the court's interpretive rulemaking. which announced to extreme deference to the employer today that reflects the freedom of employers during Jim Crow and the time period leading to the enactment of Title VII. I conclude that people of color in the contemporary workplace continue to endure disfavored jobs, irregular hiring practices, race-based job assignments, and workplace indignities and harassment that harken back to slavery and Jim Crow, a time when blacks were relegated to the harshest working conditions imaginable. I will share some examples in a moment of this phenomenon that I describe here. But at this juncture, suffice it to say that Title VII has not served to provide the gateway for greater inclusion in American economic life, as Dr. King and others envisioned as they traveled around the South, engaging with various municipalities to increase economic opportunities. These echoes of Jim Crow, as I call them, in the contemporary workplace cannot transcend their social, historical, and cultural meanings. I argue that these narratives are damaging precisely because of their historical contingency and the court's failure to appreciate the complex human and organizational dimensions of the contemporary workplace, which manifest a far more complex social environment than the courts are willing to recognize. So this is an important anniversary, right? Anniversaries are important. When you think of the age of 50, I'm not there yet, not quite, but when one turns 50, I understand, for example, that you have endured the experimentation of your 20s, the frolics and detours of your 30s, and matured to a point of ripeness based on experience, history, and courage to be who you are. Not so much with Title VII. The growth and maturation of Title VII has been stunted. The advancement of Title VII law suffers as procedure, namely summary judgment and related procedural devices, have become the primary route to making law in this area. I've been in a bit of a reflective mode, as many of you have been this year, with the 40th anniversary of McDonnell Douglas, which is a key decision upon which the court's jurisprudence began in this area, the 50th anniversary of the March on Washington for Jobs and Freedom, and the 50th anniversary of Title VII. As America experiences a progressive browning in the makeup and experiences of the workplace, what's interesting is that African American workers in the contemporary workplace, their experiences do not align with the images of this reality. There is such a stark, disappointing reflection of the lack of inclusion as reflected in much of the demographic data. Notwithstanding an African American president in the White House, the demographics of America's boardrooms, senior management teams, supervisory ranks, nor the rank and file of today's workplaces reflect the qualified available labor pool within the community from which applicants are drawn. Where there exists some representative capacity, it is most often at the lowest rungs of a particular workplace with little opportunity for advancement. Additionally, the rhetoric of post-racialism and new narratives of merit continue to be amplified as the prevalence of bias in society continues to deepen. Notwithstanding the egalitarian ethic upon which Title VII is based, workers of color, and particularly African American workers, experience discrimination and disparate treatment in the terms, conditions, and privileges of employment. While I come to this with a bit of post-racial fatigue, suspicion of the progressive narrative, I am an optimist. I live in the legacy and the wake and the spirit of the late Dr. Martin Luther King and all of the freedom fighters, men, women, and children who joined the social movement at that time that impacted the hearts and minds of this country and its leaders. Surely, there was a constellation of forces that led to the enactment of Title VII. So I do approach this topic with a bit of realism. My title is intentionally provocative. Surely, I am inspired by the brilliant work of Michelle Alexander in her intervention, The New Jim Crow, where she courageously offers stunning accounts of the rebirth of the caste system. in America's criminal justice system through mass incarceration. She courageously mapped the past to the present, tracing the unconscionable treatment and brutal control of Black people, slavery, Jim Crow, mass incarceration, debunking the myth of fairness, equity, and inclusion in the fabric of society. She asserts that through the warehousing of disproportionate numbers of Black men and women in prisons, we have not ended racial caste in America. We have merely redesigned it. Michelle Alexander's intentional invocation and historical framing models a way of tying the past to the present. I submit, as Alexander does in her work, that in the contemporary workplace, a similar phenomenon is at stake. After considering her premise and the evidence to support it, it provides a method of describing the limitations of Title VII 50 years after its enactment. Achieving employment equity in the American workplace remains an enduring quandary. Barriers to entry, at least in the most blatant forms, have diminished appreciably for women, people of color, and other marginalized individuals. Notwithstanding the important gains over the years in dismantling impediments to access, efforts to harness the valuable contributions from a blended workforce have not attained this ideal. The prevalence of societal discrimination in education, housing, transportation, consumer markets, and employment is simply undeniable. A country with a complex labor history, the United States continues to struggle with reconciling its past atrocities, notably slavery and the bondage of African peoples, the continued oppression through Jim Crow, with its articulated constitutional values of equality and justice for all, and reconciling and harmonizing this tension through the codification of the egalitarian ethic in Title VII. Despite the implementation of a national policy on equal employment opportunity and 50 years of jurisprudential exploration under Title VII, why does employment discrimination remain a central justice issue for American society? I will suggest that workplace equity remains elusive, particularly for African Americans, in large part because of an intense ideological divide over the proper conception of equality that ought to shape the nation's policy and approach to access and inclusion in American society. It is the age-old equal opportunity, equal achievement debate that we witness in surveying the Supreme Court's marquee decisions in this area, and the continued and enduring presumptions of incompetence and stereotypes subscribed to brown workers in the contemporary workplace. After decades of oppressive employment systems of slavery and legal segregation and slave hiring, American policy toward workplace inclusion took a dramatic turn in the early 1960s when Title VII was enacted. This progress over the year was years in the making and embodied colorblindness as the antidote to oppression in American society. Briefly, prior to this time period, the United States had not adopted a legislative stance on equal employment opportunity. In fact, discrimination in employment was the order of the day and mirrored the prevailing societal attitudes and behaviors. The law not only tolerated racial differences, but it also facilitated racial hierarchy in society, including in the employer-employee relationship. For example, even after the abolishment of slavery and forced labor, former slaves, in order to survive, sold their services to the very employers who had held them in bondage for years. David Martin chronicles this phenomenon of slave hiring in a book titled Divided Mastery, Slave Hiring in the New South, a 2004 publication. And he also shows how it evolved into sharecropping, which produced a system that thwarted the financial independence of blacks in this country and has lasting effects today. The enactment of Title VII codified the policy ideal that an inclusive society embraced all individuals without regard to race or ethnicity. This positive stance to advance the rights of African Americans and others in all facets of American life, without regard to skin color, was embraced by civil rights leaders, past presidents, and many in the society at large. Somewhere along the way, however, this positive conception of the colorblind ideal became strained, subverted, in fact, by those who sought retrenchment of progressive endeavors toward economic justice, including race-conscious affirmative action measures. Trina Jones has eloquently documented the shift describing it as a period in which American courts abandoned colorblindness as a proactive tool for social change, giving way to a mechanism for validating the status quo. Prior to the emergence of this negative conception of affirmative action, however, diversity efforts became part and parcel of organizational growth. As employers, particularly those in the private sector, sought to amass the building blocks to revitalize their businesses and capture competitive global advantage, enhancing diversity became integral to that strategic plan. Employers engaged in targeted efforts to articulate their commitments to diversity, to engage in direct action to promote inclusiveness, and to broadcast their efforts far and wide. Propelled by the apparent decisiveness of the enactment of Title VII and the passionate determination of the Civil Rights Movement, colorblindness became a constant refrain in America's sonata on equality. Accordingly, as the jurisprudence of workplace law evolved, we became a society that spoke in colorblind terms and professed to think in colorblind terms, further blurring the understanding of what constitutes discrimination in employment. Enter post-racialism. The notion that in American society, race no longer represents an impediment to opportunity. It no longer accounts for any real or perceived inequality in society. The election of President Barack Obama as the nation's first black president deepened this sentiment. This viewpoint was reinforced by the campaign and re-election of President Obama to the country's highest leadership post for a second term. And I just want to say a little bit about that in light of the images that were rolling earlier. Since he became president in 2008, a resurgence of the colorblind rhetoric has taken hold, and not only in the political sphere. Even before then Senator Barack Obama gained the nomination for the presidency, many in American society began speculating on what an Obama win would signal with respect to equality. Progressives and conservatives engaged in what appeared to be an interesting dance of convergence, each side overcompensating for the interesting confluence of circumstances that resulted in a black man being elected to the nation's highest office. For example, conservatives viewed Obama's nomination as the antidote to the pesky cries of civil rights groups, and more progressive minds celebrated the moment as representative of its open-minded acceptance. Underneath this veneer of colorblindness lay the perception that Obama was somehow different from the stereotypical black man in American society. Barack Obama's election as the first black president of the United States was a sight to behold for sure. As the country savored this pinnacle achievement, buoyed by the promise of a new beginning, post-racialism sentiment intensified. Yet, Obama's ascendancy to the presidency itself served as a stark reminder of the country's complicated history and continuing legacy of oppression. During the campaign, race became spectacle. From exaggerated, caricatured images of Obama wearing a turban or portrayed with ribs and buckets of fried chicken, to confusing tales of his religious belief, stereotypical depictions of life in the White House with the black first family, and horrid images of a seductively dressed Michelle Obama tied to a tree. This saga of racial animosity continued during the recent re-election campaign with hyper-focus on side issues, such as locating President Obama's Hawaiian birth certificate and college transcripts, for example. These inflammatory images underscored that racism is deeply braided into the fabric of our nation and debunked the myth of a post-racial society. Thus, Obama's election served merely as a distraction from dealing with the reality of America's storied past regarding race, rights, and equality. This fallacy continues to bolster the view that race matters are per se. How much time do I have left? Zero. Okay. All right. So let me end here because I did want to share one case with you, and I'll end with this case if you would allow me to do so. As an example of sort of what I call the echoes of Jim Crow. So this is a Seventh Circuit case involving a woman named Brenda Cheney. She was a worker at an Indiana nursing home. And she filed a lawsuit alleging race discrimination when the nursing home, her employer repeatedly instructed her to refrain from treating white patients, to basically honor their preferences, their racial preferences of who would provide them care. That opinion, the trial court granted summary judgment for the employer, and it went up on appeal to the Seventh Circuit. A unanimous panel that was led by an African-American female judge, Ann Claire Williams, revived Brenda Cheney's claims, and essentially sort of highlights, I think, aspects of Jim Crowism in the contemporary workplace. So the employer tolerated racial hostility in the context of this individual's work. It portrayed a willingness basically to accede to the patient's racial preference, and that hostility, as it was described by this plaintiff, is what is so poignant. She essentially said that the daily reminders that she would receive on her assignment sheet that would basically direct to which room she could go in and she could not go in created an oppressive workplace environment for her. And so if you think about that, they acted to foster and engender a racially charged work environment through the assignment sheets that unambiguously and daily reminded Brenda Cheney and her co-workers that certain residents preferred black nurses. Unlike her white co-workers, she was restricted in the rooms that she could enter, the care that she could provide, and the patients that she could assist. And so this is just one of many examples that I'm happy to talk about later that I think really reflect the essence of continued oppression in the contemporary workplace. And I believe that it is something that the contemporary courts and judges do not fully appreciate when they are evaluating the evidence of discrimination in current context.
Thank you, Professor Martin. We're now going to have Professor Aziz make her presentation on her paper entitled Veil Discrimination, Coercive Assimilationism in the Workplace.
There we go. Okay. There's no mic right there. Well, thank you very much. It's a pleasure to be here. I want to thank Professor Baines, Professor Nelson, Professor Wade, Professor Gregory, and all of the student leaders who organized this excellent symposium. And I'm very honored to be among some of the best professors and scholars on Title VII. So what I want to talk about today is something that I consider a very under-researched area, not necessarily the area of the law, but particular communities that are targeted quite a bit by the public in ways that the public doesn't question or seems to find more acceptable in terms of what I think is very biased expressions. However, they're not addressed in the scholarship. But I'm going to address them in the context of what we've been talking about thus far, which is implicit bias and stereotyping. So I came to this research by asking this normative question, which is, does diversity mean simply a colorful picture of different looking people? Or is it more substantive in terms of the differences in viewpoints and cultural displays and behaviors and communication styles and social identities? Because I find that it's a buzzword, and there's articles literally calling it diversity as a buzzword. And I don't think that that is going to get us where we want to get in terms of if we're serious about diversity and equality and anti-discrimination. So I really want us to challenge ourselves, particularly workplaces and educational institutions, to define diversity more meaningfully. But when we do that, we have to then ask, are our laws, particularly Title VII, allowing us to do that? Are they facilitating it? So, leading to the doctrinal question, is should Title VII protect employees who seek to perform their gender, racial, ethnic, and religious identities in ways that do not comport with assimilationist demands? as defined by the socially dominant group's norms, values, and preferences. And so this is when you get into more nuanced, what I call discrimination, and it is a product of implicit bias, which is you have to be the right type of black, the right type of Arab, the right type of Latino. And it's not enough, in my opinion. We're getting to a point, not in many places we're not getting to this point even, but we are starting to get to a point where we have a relatively colorful picture, what I call facetiously. But who are the people that are let in, and is there actually a perpetuation of discrimination underneath the facially colorful or diverse picture? So I decided to answer that question by looking at Muslim women of color's experiences in the workplace, because then I could accomplish two things. One is addressing that more substantive, normative, and doctrinal question, and also by focusing in on this group that I think is under-researched. So let's ask these two questions. The first is, do Muslim women of color whose religious, racial, ethnic, and gendered identities are not in compliance with what I call coercive assimilationist identity performance demands have a cause for action for disparate treatment? So coercive assimilationism is assimilationism that you don't voluntarily adhere to, or that you begrudgingly adhere to, that you don't naturally. So there are people who will behave in certain ways that one could say is assimilationist, but they're extremely comfortable with it. It's very natural, it's very authentic, and our identities change with time, and they're shaped by our families and where we were raised and whether we travel or not and who we associate with. So I fully acknowledge that it's ultimately about individual autonomy and authenticity. But what if there are people who either refuse to do so or cannot do so? And does the law protect them? And the answer at all, is it affected by individuals or groups of people who are caught in a catch-22, that even if they are willing to accommodate coercive assimilationism, they're still going to be reprimanded because there's so many different stereotypes that they're trying to accommodate or avoid, that it's almost a no-win situation, which I think then really brings to the forefront why identity performance theory is so problematic. So here are some of the theories that I discussed in my paper. I won't go into detail today because I don't have enough time, but just to let you know what the theories that are at the underpinning this discussion. First is you have the age-old, decades-long debate in the United States and many other countries, multiculturalism versus assimilationism. Are we going to adopt multiculturalism, or are we going to adopt assimilationism? And there's debates on both sides. Ultimately, I'm concerned with two things, and I admittedly come out as a multiculturalist. But there are risks with the multiculturalism, which is essentialism. And so I acknowledge that by allowing people to, quote unquote, be themselves and perform their identities, you may risk essentializing that group of people. So by trying to, quote unquote, liberate or bring more freedoms to these groups, you may be essentializing. Who is to say what an African American culture is? Who is to say what an Egyptian culture is? Who is to say what a Muslim identity is? So there is a risk of essentialization by virtue of that endeavor. So I acknowledge that. But ultimately, the subordinating aspect of assimilation I find to be a higher risk. So it's about weighing the risks and benefits. And assimilationism, in my opinion, is highly subordinating, particularly because it tends to be based on the majority group. So who is the majority group at this point in history in America? It's going to change, I suspect, and it's changing. But when you're looking at the workplace and who's leading the workplace, who's defining the norms, it tends to be white, male, Protestant, heterosexual. Now, it'll be interesting to see in 50 or 100 years how that's going to change. And there are some workplaces that's not necessarily the case. But if you're looking at the macro picture. The other issue is identity performance theory, which I'll go into detail later in the presentation. And then stereotyping and stigmatization, which was what Professor Martin talked about, particularly with implicit bias. So many of us, stereotyping is a natural human phenomenon, and social psychologists, there's no way to avoid it. The issue is, how can you not impose negative stereotypes on employees such that they're not getting hired, they're not getting fair access to training or equal access to training, equal access to promotion, equal access to pay that's commensurate with their experience and education, et cetera. And how can you not stigmatize them based on these negative stereotypes, such that two people within two different demographic groups can be behaving exactly the same way, but one triggers a stereotype and is stigmatized and the other doesn't. The easiest example is male-female. You have a woman, very assertive, very aggressive, very ambitious, very career-driven, and kind of a to-the-point type of person. Well, what are the stereotypes that she tends to have to confront? She is the B word, the bitch. I mean, that's a very real issue, particularly at white-collar jobs. She is aggressive, she's mean, she lacks social skills, she's not professional. However, if you take a male, particularly a white male, he's a rising star, he's a superstar, he's gonna be a partner one day. It is same behavior, but there are different stereotypes. So that's the most obvious example, but that applies in many other contexts. And then finally, intersectionality theory, which makes things even more complicated. Because when you're dealing with people at the intersection of different identities and different, which entail different stereotypes, for example, a Muslim woman, which I'll get to in a minute, she may be, she's dealing with the stereotypes of Muslims, which are stereotyped now post 9/11 and somewhat pre 9/11 as terrorists, violent, barbaric, disloyal, suspect. They have to prove otherwise. She's a Muslim woman. What are a Muslim woman stereotypes? She's meek, she's oppressed, she's forced to wear that headscarf. It surely can't be a choice. She's probably gets less access to education and resources within the family. She's domesticated. So there's all these negative stereotypes that you see about what Muslim women are, and that they need to be saved by American feminists. Of course, that's not addressing the issue that American women have, non-Muslim American women. So, and then she's also dealing, let's say she's an Arab or she's Pakistani. Whatever biases and stereotypes relate to those. So there's this intersectionality of biases. So it makes things very complicated. Okay. So let's talk about identity performance with regard to women, because this is really where I think implicit bias is very, what is the right term? Plays a big role. Okay, so you've got converting, passing, and covering. For those of you who may be familiar with Kenji Yoshino's work, he's written a lot on this, and so I'm applying it to Muslim women. So how does a Muslim woman convert? So when you convert out of your identity, you essentially become a different identity. Say, I am no longer X, I'm something else. So a Muslim woman would literally convert from Islam to Christianity, the majority religion. She would change her name legally to an Anglo name. She would become Anglo, the dominant class. And she would marry outside the faith and the culture. Her children would not have the names or the identity. She is essentially outside. Now, you can't do that unless phenotypically and morphologically you kind of quote unquote look the part. But within, for example, Middle Eastern cultures, there are people who can do that. If you're looking at people from Syria or Palestine or Lebanon, you can literally convert out of that identity. Passing is similar. You have to quote unquote look the part, look like a member of the majority, but it's where you're not totally converting out, you're just passing. So if you think of historically where you had African Americans who would pass as whites, primarily so that they could have access to certain resources and employment and being able to sit in the front of a bus or a train or even ride a train. So it's the same concept. So if someone's name is Khadija, she'll go by Katie. The Arab, if she's Arab, she'll pretend she's Anglo. Who she marries, who she associates with, her behaviors, her mannerisms, her communication style. She is trying to hide her Muslim identity and her Arab identity. And oftentimes, if someone discovers that her name is Khadija, because somehow her formal name comes in, they will ask her, I had no idea. I had no idea you were a Muslim. I had no idea you were an Arab. Just dismissively say, well, it's not really important. That's not part of that's not really who I am. So very few people can do that. Finally, you have covering. And in this context, you have, this is the most common form of identity performance for many people in the workplace, which is the way you dress. So you will not, if you're a Muslim woman of color and you're dealing with these stereotypes, you will dress like I'm dressed. You will certainly not dress in anything that is considered ethnic. anything that is that makes your identity, your Muslim identity or your racial identity salient. The way you will laugh at jokes against Muslims that call them terrorists. You will engage in those types of what we call self-hating instead of complaining about it and saying, hey, that was really racist or that was really biased. You will try to be good in terms of being compliant in your behavior and your communication style. And so ultimately you have multiple identities. You're somebody at work and you're somebody else at home. You leave your identity at the door. This is very common among minorities in general, particularly corporate law firms, corporate firms where you are one person at home and one person at work. Now you may argue, well, we all have to do that to some extent, and that's true. We all have to perform our identities. How we act at a concert is not going to be how we act in this courtroom. The question is, are those performance pressures related to an immutable characteristic? Are they related to your identity, your gender identity, your racial identity, your ethnic identity, your religious identity? And I argue that if it is, then Title VII should be triggered, particularly if that is the basis for an adverse action. Now, I'll just note that these are not things that are minor. These are not preferences in terms of these issues have very, very serious psychological and dignitary harms. And the social psychology literature has established that, particularly with African Americans and Latinos. There have been many studies. There's not as many with Muslims yet, but it's growing. But the point is that when you have these pressures to perform and you are unable to do it, or you're able, even if you're able to do it, it creates a lot of psychological harms, lowered self-esteem, depression, cardiovascular health problems, microaggressions, and you feel that you live in a hostile social world. So the question is, how can Title VII incorporate this? Sorry. I just want to point out, this is kind of where I think there is a hook. Oftentimes when the employer comes and says, look, I didn't promote her because she's not professional. Her peers just don't like her. She just didn't fit in. She was a poor communicator. The evaluations were lukewarm. And I want courts to challenge that and say, well, who defines what professionalism is? And what does professionalism mean? Because this term has also become this buzzword, and it's assumed that we all just know what it is. But it's really subjectively defined by the majority group, whoever is in control. And as I said, if you're looking, and I'm focused a lot on white-collar jobs, many of the jobs you'll be going into, particularly if you're going into big law. And so when you ask about certain workplace rules, so there's the spoken and the unspoken rules, but if you have spoken rules, such as the way you wear your hair, you can't wear dreadlocks, you can't wear braids, you can't have cornrows. If you're a man, you can't have long hair. If you're a woman and you have a buzz cut, courts tend to be very deferential. And I want to challenge that and say, well, if it's not directly related to the performance of the job, then it shouldn't necessarily be, you shouldn't defer so much. You should ask yourself, why do you have these rules? And are these rules essentially based on negative stereotypes of particular ethnic, racial, gender, or religious groups? And if so, then the employer should not be permitted to do so. Similarly, you have places where you can't speak a foreign language during breaks. There's a lot of issues with speaking Spanish. Is it the same? Why are they doing that? Is it an aversion maybe to the culture and the people and the negative stereotypes? Would the same attitude is there the same attitude towards people who speak French, people who speak German? And asking those questions. Similarly with dress style. And so, again, these are just some of these buzzwords that are used by employers to claim their non-discriminatory purposes. And some of them, they are signals, and when you say insubordination, what does that mean? And when you say that to a woman, what does that mean? And when you say that to an African American, what does that mean? He has a bad attitude. That is a very common veiled racial slur, because there are stereotypes of African American men being aggressive and violent and insubordinate, and African American women being too strong, too tough. Every group has negative stereotypes that many of us have it in our subconscious, and some of them are explicit. And I want courts to challenge those. So if you look at these two rows, ask yourself, are they analogous? So I'm not arguing you can't have workplace rules, and I'm not arguing that employers cannot regulate in some way their workplace environment because they need to be productive. But if you, for example, tell men you need to have short hair and you tell women you have to have long hair, is that the same thing? What men must wear ties and women must wear their hair down, versus you can't have tattoos and you have to have skirts that are below the knee, or they have to be above the knee. No unnatural hair color. You can't have red, purple hair. But women, you can't wear pants. You can't wear jeans to work. You can't have cornrows. Do you see the difference? Do you see how some of the one on the right-hand side, there are very clear historical associations, and this is what I want courts to start looking at, is when you tell a woman you can't wear pants, that there is a history behind that. And it's not the same as telling a man you have to wear a tie. And that's the deeper level that I want. And I realize it's a provocative thesis, but I think it's something that digs into the implicit bias issue. I don't have enough time to go into the doctrine, but I will just tell you that much of what I'm arguing is essentially based on Price Waterhouse, where there is a jurisprudence for gender stereotyping, and I essentially want it to now expand to ethnic, racial, and religious stereotyping, because courts have generally not done that. And with Muslim women in particular, there is a triple bind. To be a good Muslim woman, from the majoritarian perspective, I proffer, is to be westernized, to uncover your body and uncover your hair, to be strong and assertive, to break the stereotype that you're meek, to break the stereotype that you're oppressed. And so you become this exotified woman, good Muslim woman. To be a good woman, however, you need to be deferential, you need to be pleasant, you need to smile all the time, you need to be firm but not too aggressive and assertive. And so sometimes that creates a clash. And to be a good Muslim, you need to be passive. You need to, especially if you're of an immigrant background, you need to show that you're grateful to be in the United States, that you're not here to take anybody's job, and that you're going to accept all kinds of negative statements about where you come from, and you won't challenge that, because that is, again, being unpatriotic and not challenging or to challenge authority. But that can then trigger the bad Muslim woman, meek, oppressed, can't lead. So do you see how there are all of these conflicting stereotypes?
Well, thank you, Professor. Just in the interest of time.
I'm sorry, yeah, it's taking so long, but I'll just end with this: is why do we care? This is where I think we all should care, beyond just the subgroup, is that the individual harms, the low status groups get stigmatized, and that actually leads to separatism and balkanization. And the social psychology has shown that groups that are stigmatized, whatever group, many of them will separate and self-segregate. And that, in my opinion, over the long run is very bad for society. And I will end with that, and thank you for your patience.
And now we'll have esteemed journalist Kathleen Wells.
It's my turn.
Yes.
So, I'm excited to present this information to everyone here. First, I'd like, well, you know, when reality, how do I want to put it? When theory bumps into reality, you have a chaos. So I'm going to talk to you about two cases. I'm going to talk about reality. But first, I want to thank Professor Gregory for extending the invitation for me to be here. I'm delighted to be here to talk about Title VII at 50. And you know what? And I like my conversations to be interactive and dynamic. That's why I run my radio show. So since you guys are all legal professionals, I'm going to ask you some questions. For instance, has anyone said that Title VII has been eviscerated or minimized or diminished or circumvented or trashed or smashed? I mean, has anyone said that yet to you guys? I'm asking you, you are in the field, you work in the field. Has anyone yet said that in one of the seminars? Have you heard that yet at all? I guess not. Well, I mean, if you do look at the data, you know it's true. So I mean, we're just talking as if it's still alive. It's dead. In fact, Judge Mark Bennett said that Title VII needs a funeral. No, not Title VII, summary judgments, because the federal judges are basically smashing, killing Title VII by granting summary judgment motions. They've done data on this. It's like 70 to 80% of employment discrimination cases, Title VII cases, are being lost at the summary judgment level. I mean, do we know this or not? Yes. And we're speaking as if it's still alive, as if, well, you didn't actually, but, but you know, and I have Michelle Alexander on my radio show, and she's written a book, the legal scholar Michelle Alexander, who's written the book, Mass Incarceration, the New Jim Crow. She's talking about the criminal context. But we're learning now that it's happening, that in the criminal context, blacks are considered second-class citizens. They've been relegated to a second-class status. But what I've learned recently, in the civil context, the same is true. Blacks are in a second-class status. And I'm going to talk to you about two specific cases that deal with racial discrimination. And you know, we are very reluctant to talk about racism. It's a delicate topic, and we're reluctant to talk about corruption in our federal court. We don't want to talk about that, but we've got to talk about it. We've got to talk about it. That's the only way we're going to solve it. We've got to face the truth. We cannot intellectualize reality. We've got to face the truth. We've got to face reality. So the two, and in fact, didn't Eric Holder say we are a nation of cowards? Didn't he say that to us? That we're afraid to discuss race? That I mean, does the mainstream media even discuss it properly? No, it doesn't. I have Dr. Frances Cress Wellesley on my radio show. She's been in the business 30, 40 years talking about racism, what it is, its definition, and you won't find it in Wikipedia. Do you see Dr. Frances Cress Wellesley in the mainstream media? Do you ever see her there? No. I have Dr. Claude Anderson on my radio show. He talks about racism is a group-based phenomenon. Do we ever hear that in the mainstream media or even the alternative media, ever? It's a group-based phenomenon. We're talking about what is happening to groups. That's what racism is. You never hear that. And I think it's important that we get a handle on what racism is. People, oh, that's racist, that's racist. No, that's not racist. Individual instances of someone being mean or someone not liking someone is not racism. So let me get to the cases now. So there are two cases. One is Rowe Entertainment versus William Morris, and the other is Marcus Washington versus William Morris. So you'll notice it's the same defendant in both cases, right? You notice that fact. So let's get to Rowe. I'm going to go into specifics about each case, and initially I'm going to start with Rowe Entertainment versus William Morris. So Leonard Rowe is the plaintiff, and he brought a racial discrimination lawsuit against William Morris and, in fact, 33 other defendants. He settled with 28 out of the 33 defendants, but 5 of the defendants, William Morris and CAA, did not settle. And in fact, despite the evidence that, oh, I only have 10 minutes. I mean, I'm just getting started. He's telling me I have 10 minutes. I'm just getting started, and you guys want to hear about these cases. So let me just start reading. So, because I only have 10 minutes. So anyway, let me give you the evidence. Rowe was the plaintiff. He was bringing his lawsuit on behalf of the Black Concert Promoters Association. His claims were civil rights violation and antitrust violation. And in the 118-year history of the William Morris Agency, which is the world's largest talent agency, no black concert promoter had ever been allowed to engage in a contract with a white entertainer or artist for a live contract performance. Yet white concert promoters are able to engage in contracts with artists of all races. Another fact, black concert promoters always have been required to pay 50% deposit upfront for the artists that they were contracted to promote, which consists naturally of only black artists, because black concert promoters can't engage in contracts with white, purple, brown artists. Another fact, white concert promoters only had to pay 0 to 10% as a deposit for an artist of any color. And as I said before, blacks had to pay 50%. And these are just two examples of the disparities and inequities between white concert promoters and black concert promoters. Leonard Rowe gave 10 boxes of evidence. He had, and in that 10 boxes of evidence, he had over 2,600 contracts, contracts that stated things like, don't tell the blacks, don't divulge to the blacks. White concert promoters gave testimony under deposition saying, yes, what we have here is a good old boys club. White concert promoters said under oath, when asked explicitly, are black concert promoters treated fairly? White concert promoters would say no emphatically. 10 boxes of evidence is what he presented. But the smoking gun, and both Marcus Washington's case and Leonard Rowe's case both have smoking guns, but you don't really need the smoking gun. But the smoking gun in Marcus Washington and Leonard Rowe's case is that despite paying $200,000 to get email evidence, to get the email evidence from William Morris, his counsel told him, despite the fact that we spent $200,000 to get this email evidence, the backup data from William Morris and CAA, his counsel told him nothing was fruitful. We had no useful information. So when Leonard Rowe was sitting in his counsel's office and his counsel turned his back and answered the phone, he looked and saw on his desk that there was a stack of papers, and on the sheet of the first sheet said Rowe Entertainment versus William Morris, and that first sheet had nigger, 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 nigger all the way down the entire first sheet of paper. And when Mr. Rowe asked his counsel, well, what is that? Now remember, his counsel told him, even though you spent $200,000, you've lost that $200,000. It doesn't matter. We didn't find anything useful. We didn't find anything useful from William Morris's emails. And he sees on the front sheet a line saying nigger, 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 all the way down. So he went to his other counsel and said, you've got to get this document. What's going on here? Because when he asked his counsel at what firm? Denton's, his name is Mr. Attorney Heslin, when he asked him, what is that document? He said, oh, you weren't supposed to see it, and he turned it over. So Leonard Rowe called his other counsel in Florida and said, hey, listen, Mr. Heslin at Denton's LLP has a document that has nigger all the way written down. He told me there was no derogatory statements. Come to find out, executives at William Morris have called black people spooks, coons, hundreds of times, Uncle Tom, spades, hundreds of times. Is this not explosive evidence? Would this not be material evidence? Despite the other evidence, despite the 10 boxes, the contracts, the disparity in deposits, the fact that black concert promoters can only contract with black artists, would that not be material information that should be decided by a jury? That's what I want to ask you. What do you think? What do you think? I mean, would you expect that to be material evidence to a racial discrimination case? What do you think?
Yeah. Why did the lawyer turn it over?
That's what I'm getting to. Remember, but I don't have enough time, but remember that there were 33 defendants and 28 settled whose evidence was less egregious than the 5 remaining. They settled. But the 5 defendants with the most egregious evidence and the wealthiest defendants, William Morris and CAA, win a summary judgment motion. They win a summary judgment motion. I have a little more time, but I want to get to Marcus Washington's case because he's here. So I want to get to that case right now because my time is limited. So let me turn to Marcus Washington's case. His case is Marcus Washington versus William Morris Endeavor. Same defendant, right? And in December 2010, Marcus Washington was then employed by William Morris, filed his racial discrimination case against William Morris in the Southern District in New York. And I want to let you know who the judge is. The judge is Robert P. Patterson in the Southern District of New York. So he had been discriminated against based on the fact that William Morris had failed to hire and/or promote African Americans to the position of agent. He alleged that William Morris had discriminated against blacks for more than a century. We're talking 118 years. And in 118 years, I mean, William Morris maybe had a handful, 2 or 3. In fact, I know between 1861 and 1963, William Morris only had 1 black agent. And then when Marcus Washington was employed there in 2010, there were none. So there was this 30-year period. When asked specifically, how many black agents have you had, William Morris, they will never tell you. But we know that in a 30-year period is the only time that they may have had more than 0. But they will never say exactly how many black agents they've had. They've had a long history of 118 years. Okay, so let me give you more information because it gets worse, believe me. It's worse than the nigger emails, okay? So upon hiring Mr. Washington, he had executed an arbitration agreement like most employers require. So when he went to federal court, the federal judge said, go to arbitration, the American Arbitration Association. He goes to the American Arbitration Association. Marcus Washington has no law degree. He's a pro se litigant. And he's not savvy enough to be an agent, but he goes to arbitration against one of the biggest law firms in the country, Loeb & Loeb, and he comes out victorious. He comes out victorious with no law degree. And I mean, and he did a large volume of documents. So what do you think when he comes out victorious? I'm asking the audience, what do you think when the arbitrator says that William Morris has discriminated against Marcus Washington based on federal, state, and local laws based on his race? What do you think William Morris's lawyers did?
Vacate.
What did you say?
Motion to vacate.
Where are you? I don't. What do you think?
Vacate the arbitration award.
What they did exactly? They moved to have the arbitrator disqualified. But then the question is, what does the Arbitration Association do? What is the arbitration? If William Morris moves to have the award that is issued,
They disqualify the arbitrator.
they disqualify the arbitrator, and then what does the this is what the lawyers move to have the arbitrator disqualified. But what does the Arbitration Association, they have their rules, right? Doesn't the AAA have their own rules?
Yes.
Would they follow that rule if it's against their rule? Well, they did. They got rid of that arbitrator. It's in their standards, it's in their rules. Once an arbitrator issues an award, you can't get rid of the arbitrator. But the AAA got rid of the arbitrator. And why? Why? Oh, my time is up. How do I want to finish? I mean, my time is up. And it's so fascinating. In fact, I've written about both cases, and I have copies. I'll put them on the desk, and they can be found in Counterpunch and Truth Out. And I've written about both cases. How do I want to end this? Oh, this is even worse. Because there's so much information, and I want you all to know it and embrace it and realize that, hey, it's not happening. It's never happening. And that's what, it's not happening for black folks in America, unfortunately. Title VII is not happening for us. So this is the kicker. So we were talking about Marcus Washington's case. They got rid of the arbitrator, and the new arbitrator wants to come in and vacate the award. Someone said that right. But what's the kicker? The lead counsel for William Morris, who's in Loeb, at the lawyer at Loeb & Loeb, who is he married to? No, he's married to one of the vice presidents for the AAA. Was that disclosed to Marcus Washington ever? What do you think? I mean, are you seeing the pattern in the picture? that you're here. So it's like, this is reality. This is what's happening in the real world. We like theory like everyone else, right? But what is happening to plaintiffs, claimants in the real world? Okay, you guys are lawyers, right? I went to law school. If two people are literally, not just figuratively, literally in bed together, is that a conflict of interest? I mean, that's a conflict of interest. And so my time is up, I'm sorry. I am excited about this.
I'm going to be beheaded
I'm
soon.
sorry, I can talk forever. Okay, let me just say the last thing. Let me just wrap it up. So we've already decided that the arbitrator who issued the award has been disqualified based on a motion despite the rules of the AAA. And we've already decided that the lead counsel for his opposition, Loeb & Loeb, is married, never disclosed, married to one of the presidents of the AAA. They're literally in bed together. Now, when Marcus Washington goes back to the federal court to tell the judge, hey, they're married and they never told me. This is a glaring omission. He should know, right? What do you think the federal judge does? I'm going to leave it at that and let you guys, I'm going to leave it like that. I'm going to leave it like a cliffhanger or something.
And so now I'm going to introduce, last but not least, Professor Elaine Greenberg. Professor Greenberg will be presenting her paper, An Amnesty Approach to Implicit Bias and Isms in the Mediation Design. Please welcome Professor Greenberg. You're home.
Thank you. I am so thrilled to be here with my colleagues, David Gregory, Professor Baines, Professor Nelson, Professor Wade. Thank you for including me in this program. To all you students who I keep working with, and I'm thrilled you're here on a Friday to hear these important comments. And thank you to this very challenging and energizing panel. If you think this afternoon is great, you should have heard yesterday's call preparing for this discussion. The wires were vibrating. So at this late hour, I have the task of tying all these concepts together and giving you hope for the future about how we're going to deal with everything. I also want to thank Christopher Letch. Is he here, Chris? Right, who was my research assistant on this project, so thank you. All right, Title VII at 50 years. Yes, right? And as not enough of you in this room know, turning 50 is a time of celebration. And it's a time to sit back and, and say, well, look at all that has been achieved. But as with any significant birthday, even 21, it's also a time of reflection. What might I do differently going forward in this next exciting chapter? So we see with Title VII that despite all the criticisms, there is definitely a decrease in overt acts of discrimination. Doesn't mean it's still going on, as we're hearing throughout the day, but there is still a decrease in overt acts of discrimination. But what is yet to be addressed going forward by Title VII is implicit bias in the workplace. As many of us are living and experiencing and hearing about, implicit bias is live and well in the workplace, and that is yet to be addressed effectively. Let me explain. When an employee alleges that the employer has discriminated against the employee for his protected status, it's likely that both the employee and the employer are going to feel victimized, each frustrated in their quest for justice. Unless the employee has a smoking gun, the employee may be frustrated because he'll find that his case is not going to go anywhere, and he's going to feel victimized in his quest for justice. And the employer, even if the employer prevails in court, is also going to feel victimized because the employer is going to think, I did nothing wrong. Why did I have to go through this? And of course I conduct my business in a non-discriminatory way. How could this happen? Well, what we are learning more and more, that our legal system interprets Title VII to require conscious discrimination. All right, conscious discrimination, also known as the smoking gun. And as has been stated before, 70% of defendants prevail on summary judgment motions, and the remaining 30% that are left, plaintiffs are less likely to succeed in their discrimination cases unless they have the smoking gun. Now, the fact that our court system requires there to be acts of explicit, overt discrimination, this is contrary to all the growing research about discrimination. We now know that most of discrimination is caused by our unconscious acts. So here we have a court system that says, well, you're discriminated against maybe if there's a smoking gun, but the research said that's not how discrimination works. Discrimination tends to be caused by unconscious implicit biases. And if we look at the EEOC mediations that started the mediation system, we see for the cases, the discrimination cases that are mediated, the data is between 1999 and 2010. Of the 136,000 cases that were actually mediated, 70% were successfully resolved. Sounds pretty good. But if we look closer at the data, we see that more than 75% of employers have refused to participate in the EEOC mediation. As a matter of fact, specifically the data from between 2006 and 2012 shows that 84% of charging parties agreed to participate in mediation, but only 26% of defendants agreed to participate in mediation. Why? Because more often than not, defendants in discrimination cases don't believe they've done anything wrong. All right, so understandably, we see both the employee and employer may be victims when trying to resolve their discrimination conflicts using the existing dispute resolution processes. Now, let me digress. We've been hearing about implicit bias. Let me give you a quick primer. Implicit bias is known in the general media by all these different terms, including blink, system one thinking, predictably irrational. Implicit bias is an automatic, unconscious response that shapes our conscious behavior. What is happening here? I'm sorry, I'm doing the wrong ones. Okay. Implicit bias is the narrative of our larger culture and our brain's recording of that story. So implicit biases are really formed by our observations of all the discriminatory and judgmental acts that go on in our culture. Our unconscious bias influences behavior, choice, and decisions, even though we may explicitly endorse another approach. So what confuses employees and employers is you may have an employer who is yay, yay, yay about affirmative action, really makes an effort to have a very diverse workforce, but still may make decisions because of the unconscious biases that are very different than the stated beliefs, values, and intentions. And you can see that in, just hiring. You could see this in the way merit raises take place. You could see it in the way promotions are given, and you could see this with firing. Unfortunately, we all have unconscious biases. We see how it distorts reality. It can be measured. There's an implicit association test that you can take at implicitbias.harvard.edu. I invite you all to take it. It will be absolutely jarring. You will find out that in our professional lives, we are all likely to be affected by the implicit biases of others. But what's very, very sad, in our professional lives, we are all likely to discriminate against others because of our own implicit biases. So in the workplace, we see how the workplace is very much with a petri dish for implicit biases to flourish. So, and again, we see this again and again when there's any type of employment decision that allows the manager, the employer, discretion. So all things being equal, who gets hired? All things being equal, who gets higher merit raises? All things being equal, who gets promoted? All things being equal, who gets fired? Now, the research tells us there is really good news that even though this is going, we can still mitigate implicit biases. One, we can make, if we make them aware, we could control them. When people have in-person contact with individuals they may have implicit biases against, that is likely to mitigate the effect. So with job applications, if you have a pool of applicants and different names, whether it's gender or ethnicity, will trigger bias, that bias will be minimized if there is an in-person interview. We also show that priming, the introduction of positive stimuli to the people, the individuals that you may be biased against, is likely to minimize the effects of your unconscious biases. Now, Albert Einstein said we can't solve problems by using the same kind of thinking we used when we created them. So as we're talking about Title VII, I start saying, oh, wouldn't it be great if we could change the court system, right? Have them deal with not grant so many summary judgments, have a more expansive definition of discrimination as was intended, but I'm also a pragmatist, and I know it will take a long time to change the court system, but as a dispute resolution professional, I know it will take much less time to design a more effective dispute resolution program. So that's what I have been thinking about. How might we design a more effective mediation program to address implicit biases in the workplace? Now, what I am proposing is a really radically different approach, an amnesty-centric mediation design as part of a comprehensive dispute resolution system. And this is a program that EEOC, as an adjunct to their existing enforcement procedures and mediation program, could very much adopt. A very big part of this design is the goal is to develop awareness and understanding. Awareness and understanding. Again, how in the world are we going to stop unconscious discrimination caused by unconscious biases unless people become aware of them? Another part of the design, which is very controversial, is to have the conflict discourse in the mediation, again, for understanding, collaboration, and building instead of blaming. Under this amnesty model, you would bring employers and employees in, and you would talk about, it wouldn't be about labeling victim and offender. It would be, this doesn't seem fair. How can we create a better process where I get judged equally? Now, you may be sitting there in the audience saying, you gotta be kidding, how could this be real? Part of what the design would be, since employers do not want to be labeled as discriminators. They also don't want to, they want to listen to their great management lawyers and try to do everything right in most cases. And employees want to be treated fairly. If you set up a program that acknowledges people may not be aware and incentivizes participation by, one, showing there really is a problem, by inviting people to take measures, such as the IAT, to assess their own implicit biases, to provide education programs, again, that will let people talk about how to create a structure in your ambiguous decision-making that will minimize your implicit bias. And you reward companies who are having programs that are working on this problem. I think there would be greater participation and less reluctance than you have when you try to get employers and employees in programs where one is labeled victim and the other a discriminator. There would be special training for the mediators that again would be develop an awareness of their own implicit biases too, and there would be measurement for the efficacy of the program. Now, as we're talking about the next chapters, and I was talking with Paulette this morning, you know, you have to believe. You have to believe to do this, to be in dispute resolution system design, and to really want Title VII to go into a next chapter and deal with implicit bias. You have to believe in the goodness and humanity of individuals. And designing an amnesty-centric mediation program, I believe that we could get people involved in participation and really help ideally eradicate discrimination in the workplace, because that is a dream we all want to achieve. Thank you.
First off, I want to thank everyone for their wonderful presentations and discussions. And I'm going to pose a question and then also go back and forth with the audience and see, you know, what questions you may have for the panelists. I think my question now pretty much ties in the themes touched on by everyone up here today. The first question I have is, has the enforcement of Title VII kept pace with the evolution of discrimination in the workplace, from explicit overt acts of discrimination to implicit bias? I'm going to open the floor. Who would like to go or take a stab at that question first? Okay.
I think that's the answer is no. The challenge is what's next. I think one idea to think about, our scholars are calling more for something called the social framework community, which is the incorporation of social sciences into the evidentiary record of Title VII cases and other discrimination cases. Because I think that judges are not very well versed. They apply layperson understandings of how bias, stereotyping, and stigmatization works. And implicit bias, as Professor Greenberg stated, there's a lot of social science out there, the empirical studies that have been conducted and continue to be conducted. So I would proffer that the judicial system and lawyers can assist in that, need to leverage that information to educate judges and juries about the new, different manifestations of discrimination in this quote-unquote post-racial world that Professor Martin insightfully discussed.
Well, I agree with some caution though, because as we were all talking about this, you know, the social science research shows how much of our thought and behavior, as much as 80%, is unconscious. And if we were to follow that, how much inquiry do we feel comfortable having the court make into our unconscious? So, which is why, and that's, I think, so as we're trying to tackle this issue of implicit bias, we have to start looking not only about how what our goal is, but how in the process we feel comfortable having the court start engaging in that inquiry.
Yeah, I'd like to say something naturally. So let's take a case, the cases I was talking about. If you've got 33 defendants and you've got 28 out of the 33 settling. And William Morris is one of the biggest talent agencies in the world. And they're one of the richest, right? And they have the most egregious evidence. And the judge in this case, Robert P. Patterson, is telling them, if you go in front of a jury, you're not going to win. There's no way you're going to win in front of a jury. What would be the incentive what would incentivize the judge to give a summary judgment motion despite the standard and despite the evidence? Despite the standard for a summary judgment, despite the evidence which definitely shows discrimination, what would be the incentive for the judge to do that? You gotta be straight. You gotta be honest about what's happening in our court system. I'm asking you, what would motivate the judge, the wealthiest defendant with the most egregious evidence? And the judge is telling him, no, this is reality, this is what happened. This is what happened. The judge is telling him, no, William Morris, you're not gonna win in front of a jury. So why would the judge decide to grant a summary judgment? They have the most egregious evidence. I'm asking you. And that's what I write about. That's what I'm writing about, the corruption that is taking place in our federal courts. I mean, hey, listen, I was trained, I went to law school. I was in the system. Michelle Alexander, we went to law school. She went to Stanford, I went to Berkeley. We're there at the same time. We both believe, we're true believers in the system. But you go out in the real world and you see what's happening. You see the corruption. And I was in the system, I believed in the system. I was a true believer, but you see the corruption that is happening in the system. Why? I mean, so it doesn't matter. It doesn't matter what the standard is. It doesn't matter the definition of discrimination. When you go out, and this is what I am seeing and experiencing. I could talk about it forever, but I'm going to stop.
Professor Martin. Well, I mean, the only thing, to answer your question, Special, I don't think that Title VII, obviously, based on what I shared today, has kept up with the realities of the modern workplace. I mean, and sort of part of my point is that I don't think, in many ways, that we can honestly say that we have decolonized our workplaces. And I think some of the more current decisions, the news cases that Professor Cheryl Wade referred to earlier, cases involving explicit racial slurs and epithets, are really more pervasive than you might think. And one of, I really commend your ADR work and the idea of trying to come up with a new framework, right, for dealing with these cases. I think one of the pieces that we haven't mentioned here, and if I had more time I would have talked about, is how, obviously, not all discrimination is illegal. Title VII didn't define what constitutes discrimination. They left that up to the courts to do, right? So judges, juries are few and far between in these kinds of cases, have a tremendous amount of power. And what we know is that most of the federal judges are white and they're male. And they bring a different set of competencies, if you will, to the table when they're ferreting evidence of discrimination. And so I do think diversity on the bench is a really important piece of this process that we haven't talked about. And there are some recent studies that reflect that the race and gender of the judicial officer does impact the outcome of some of these cases. Work done by Kat Chu and Rob Kelly and some others really reflect this notion. And so I do think it's important to think about the role that judges and perhaps arbitrators and mediators play, and the kinds of biases they bring to the table, perhaps, and unconsciously so. And that certainly plays a role in definitions of discrimination that have emanated from the court's interpretive rulemaking.
I'm going to direct a question to the audience. Does anybody have a question they'd like to pose to the panelists? Okay, I'll keep going. oh, Professor Wade. Sure.
I really enjoyed the panel. I enjoyed all the presentations. I have a very narrow, small question for Sahar. You talked about the notion of passing, and in that you included mannerisms and speech patterns, and I don't remember the list of things, but I'm wondering if that notion of working one's identity and labeling it as passing because you may adopt certain speech patterns is essentializing in and of itself.
No, I think that is the risk of the project that I'm working on. So that's where the operative term is coercive assimilationism. So when I use the term passing, it's when you have the intent of, it's not authentic, which again is a problematic term. But I think ultimately what I'm trying to get at is not requiring that people of color or minorities or women have to exert an inordinate amount of energy, which also involves anxiety and stress and a hyper self-consciousness, just to do your job. And if you have to do that on your burden, you literally have an additional burden, which Carbato and Giulati talk about a lot, about how do you face that stigmatized low-status identity. And so to the extent that you're doing that in order to pass as a member of the majority group, the high-status group, then that would be passing. If it's something that is what you would identify as who you are, you were raised and born and it's very natural to you, then I wouldn't necessarily identify that as passing for this purpose. Now the question is, how do you differentiate? And that's where I think you tie it back to stereotyping, because ultimately what I want, and I just want to respond to your judge's comment, I understand what you're saying. I take a very different perspective. I'm very plaintiff. I was a plaintiff's attorney, and I'm open about that bias. I don't trust employers, and I don't think they're going to do anything they don't have to do. And I think that once you get a couple cases on the record and the judges make some decisions in a summary judgment, that's going to then allow and facilitate projects like yours, Professor Greenberg, because I just am very skeptical about trying to kind of convince all employers, but that's personal bias. But the point is, I want employers to be forced to question their decisions that may seem facially neutral and have to answer the question, how is this not associated with a stereotype? And if you can show that it is not associated with a stereotype, notwithstanding having evidence of that, so you can bring in history, you can bring in the psychological studies. So it's really shifting that burden on the employer as opposed to being deferential. We'll let you do whatever you want, but here's the very, very far out, here's the outline, the limits. And so if it's super egregious and I've got a smoking gun, notwithstanding your experience, and I understand, I know there are cases like that, then you're not liable. Otherwise, have at it, and the employees will bear that brunt.
Any other questions from the audience? Yes, sir.
I just want to thank everyone. Everyone had a wonderful presentation, but this question is specifically for Professor Martin and Professor Lee. Professor Martin, I loved your presentation about how we're not really reaching that post-racial America yet. And this also ties in with Professor Lee's presentation and Bishop versus Texas. In 2003, when the Supreme Court decided what it regrets, Justice O'Connor put that 25-year, limited or 25-year outlier of when she thought that affirmative action would not be necessary. So I just wanted to ask you, where do you think we are on the road to 2028? Are we nowhere near there, or getting there? And what should we expect when that happens?
So thanks for the question. Right, so Justice O'Connor expressed that sentiment, that hope. You know, I guess, you know, it's consistent with the Supreme Court's requirement that any affirmative action plan is only intended to eliminate imbalance with respect to gender or race, but not to maintain it. So I guess in the spirit of that requirement, that the court is also further proclaiming, as she did, that as they allow affirmative action to move forward, it's not intended to be a permanent thing to have, you know, as a permissible employer action or university setting. So, but in terms of where we are, that's very hard to say. I mean, obviously we have much inequality left to address, and so that's why these issues are still very much discussed and debated, because the issue is still very much alive. You know, I think it's good to have long-term targets, and we know what we're working towards. So we have that time frame in mind. We think, okay, we better get going. You know, the court may only be hospitable to this for how much longer. Of course, it depends on the court's makeup. But she's no longer on the court. But in terms of then evaluating on a short-term basis, on an annual basis, or however, so we see how close or far we're getting to the ultimate goal, that's helpful, because long-term goals are, for that reason, hard to assess. They're too far in the future. So, you know, I think we still have a long way to go. I don't know that I could estimate right now how much time we have left before we reach that point, but I don't think we're that close yet.
Okay, we're going to wrap up with Professor Martin's response to that.
Okay, well, I would just say that I think there's a tremendous amount of work left to be done. If you recall, since that case, when Justice O'Connor made that statement, in 2007, the Chief Justice in the parents-involved affirmative action case made a statement like this. The way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And I think that sort of thickens the plot, right? I don't think we are, while we have these aspirational goals, I don't think we are working towards them with the kind of intentionality that we need to in order to make advances. I think the one other aspect of this that really makes it difficult to ferret out discrimination, notwithstanding the unconscious nature of it, because that certainly makes it quite difficult. But I think the contemporary workplace itself has changed in the structure of work, the way in which people engage in their work, right? There's a lot of teamwork, there's a lot of collaboration, there's, you know, oftentimes not this sort of up and down hierarchical structure. There's more of a vertical sort of circle-based engagement in the context of the contemporary workplace. And you layer onto that the technological advances, social media, virtual work, right? So I think the way in which the workplace is changing and has changed, the law is not keeping up with it. And so I don't see 2025 as the year that we're going to solve it. I hate to end on such a sour note, but I will say I think we're all in this business and all doing this work because we believe that important interventions have been made in the past, including Title VII, and lots of other movements within the law and outside of the law, and we're still committed to fairness and equity in society.
Up here today with me. It was truly a pleasure to work with you guys, to interact with you, to read your papers, and to learn more about your thoughts about the future of Title VII and what work needs to be done still in order to reduce or to address discrimination in the workplace. Thank you all.
I want to take this opportunity to thank the panel too and announce a 5-minute break. But please come back because David Gregory is going to present with a roundtable a paper he's written that's going to be published in St. John's Law Review on affirmative action with Professor Lee commenting on it with several of the students who are participating. So take a 5-minute break, but make sure you come back. Thank you.
I promise we're going to be done by the appointed time. And I'll make this quick. Law is a violent thing. Judges are violent people. Robert Cover, the great theoretician, when I was at Yale Law School back in the Paleolithic era, he hit right on it, followed by Bell Hooks, the outlaw poet, who said you cannot deconstruct the master's house with the master's tools. The labor union saw 30 years ago, the National Labor Relations Act, folks, wasn't making it. It's not making it today. We need a new system. Now, what's that system going to look like? It's going to be international. What's the greatest threat today to the American economy? China. Not Chinese, but China in terms of bureaucracy and government that's thoroughly corrupt. The top investment banks are admitting that they are taking on as quote-unquote employees the sons and daughters of the Chinese government elite. So, you want to talk about employment discrimination? The United States aspirationally is well ahead of most of the rest of the world. But most of the rest of the world is increasingly looking at their economy and their geopolitics. And they better be looking at it through a Chinese Communist government mainland lens. Now, where do we stand on affirmative action? We're way ahead of everybody else in terms of major Western European competitors when it comes to conventional employment discrimination. We haven't begun to figure out how do we internationalize these norms given the state of the world today and the various political alignments. Now, I've been teaching 32 years. I took a blood oath I would never read a paper on a platform like this. And other than my little glass of water and a napkin, look, Mom, no hand, no paper. So I'll tell you what I really think. Affirmative action is a necessary, pragmatic, practical instrument to save us from killing one another. Lenin graduated top of his class at St. Petersburg Law School. He said, if you have 15% of the nation's lawyers unemployed, you're heading for a revolution. Now, with the collapse of the conventional law market, increasingly precipitous decline, death spiral pretty much, we know that there are a lot of lawyers way past 15% who do not have, or will not have productive work for the foreseeable future. We crossed Lenin's line in the sand a long time ago. That line is getting bigger and bloodier. Now, affirmative action, to look at the, say, litany of cases, I took a page, I took a number of pages from better playbooks than mine, one from Ricky Revesz, the president now of the American Law Institute, long-term dean of the NYU Law School. And he said, look, he said, our research assistants, they're the best students because they're the most motivated. He would bring them directly into a lot of his projects. So I took a page from that book several years ago, and the three folks to my left, except for Professor Lee, are my best research assistants. And they've been living with this affirmative action decision Fisher for 18 months now. And Sarah, the far end, presented it to my employment discrimination class. No professor could do a better job, at least not me. So I'm very proud of these folks. They'll take you through the details. But remember Bob Cover, justice accused, law is a violent thing.
So we had the great opportunity to work with Professor Gregory on this paper. Can you all hear me?
Yes.
And as Professor Gregory hinted at, you know, our underlying thesis is that affirmative action is rough justice. It's a tool which, there's no better tool to replace it, and it has great utility to I believe the words that Professor Gregory uses, that it's an indispensable mechanism to provide the rough justice of pragmatic political proportionality. I did not write that because I'm not as eloquent as Professor Gregory, but that is the gist of our paper. And what we did is we focused on the ramifications of Fisher versus Texas, and we came up with, we had 5 ideas that we worked with. I'll go through the first 2, and then I'll pass it down to Courtney and to Sarah very briefly. Fisher, first, we found that just generally it constrains the idea of what narrow tailoring is. It's making narrow tailoring more narrow. And second, Fisher practically disincentivizes universities from using race-conscious admissions policy because it raises the operating costs of having an affirmative action policy in place. The court doesn't give any specifics about what should be narrowly tailored or what narrow tailoring looks like. But because there's going to be greater emphasis and greater judicial scrutiny on what is a narrowly tailored plan, universities will be forced to put more time, more administrative energy, constantly updating and looking at the affirmative action plan that they have in place to make sure that it is working and it is in fact the most narrowly tailored plan that they can use. So those are the first 2 ideas we had. I'll pass it on to Courtney for the next 2.
Okay, so the next thing that we covered was the possible ramifications of the upcoming Supreme Court case, Shewitt versus Coalition to Defend Affirmative Action. And in that case, it was a challenge to an amendment. Voters amended the Michigan state constitution to prohibit affirmative action programs in public universities. And the court is about to rule on that now, and that could potentially impact the way that we see affirmative action today. The other thing that we discussed was the 25-year journey towards the end of affirmative action. So before we discussed the sunset doctrine posed by Justice O'Connor and the possibility that the court by 2028 might decide to eliminate affirmative action in public universities. So I'll pass it on to Sarah for the last one.
What we last discussed is the important milestone of going towards the 25-year journey to end affirmative action, which Justice O'Connor spoke about. And as we've delved into the topic and through our research, it's interesting to see where we've ended up. The end goal for that is 2028, and as some panelists earlier said, that we're not really there yet. Wikipedia tells us that discrimination in Title VII has ended all discrimination, but looking at these cases and looking at the real world, we know that that's not actually true. And a case like Fisher really increases the transaction costs of affirmative action and makes it more difficult to be transparent and for universities to achieve their goals of racial and ethnic diversity. And as we've looked into that, it seems that a lot of things have fallen by the wayside, especially students and educational opportunities for children of lower socioeconomic status. And that's kind of fallen out in favor of checking off a box of different racial and ethnic diversities. And that, I think, is very, very unfortunate and a difficult problem that needs to be addressed, but it's hard to address that. And I would kind of punt this to Professor Lee and ask what your opinion is on that, and do you find that the importance of Title VII remains in combating racism, or has it shifted a little bit to classism?
Yeah, so that's an interesting question that Sarah just asked at the end of her presentation. And, I think it's both. I think they are intertwined as well as separate, because classism doesn't always include race, but it does have a racial aspect that's very important to recognize. And knowing that different kinds of discrimination do intersect, that they're not these separate silos when people suffer disadvantage. I do have some thoughts, if I could offer them. Very interesting to hear about what all the students mentioned about their research on Fisher and how they regard that decision and what incentives or disincentives Fisher may give then to state universities moving now in terms of whether to use affirmative action policies that use race. And I definitely see the point that the narrowly tailored requirement under the strict scrutiny standard used for race, in the way that the Fisher Court explained, clarified, confirmed that standard for us, does seem to make that somewhat a harder standard to meet. So that seems true on the one hand, and then we might also ask, well, if this is a legal standard that the court must use to assess whether this constitutional standard is met for the program at issue, is it not part of the court's natural province to be able to look at all the evidence, and therefore they need all the evidence first from the state actor here, the state university, to be able to make that determination. What happened in Fisher, as we know, is it was decided in the Fifth Circuit on summary judgment, unlike, for instance, Grutter, which was decided after trial. So I don't know that the University of Texas at Austin they don't have the evidence to present. In fact, right now on remand in the Fifth Circuit, because the Supreme Court remanded it, clarifying the standard for the Fifth Circuit to use, they originally decided it on summary judgment because they didn't do a separate assessment on the narrowly tailored requirement. Instead, they gave deference to the university that they acted in good faith in implementing this program. So they took it at their word that there was no feasible alternative that wouldn't use race, and that they were pursuing this for that reason. But that the university now on remand has asked the Fifth Circuit, right now it's in the Fifth Circuit, the Court of Appeals, and the Fifth Circuit is trying to figure out whether they should decide this now on the merits or send it back down to the district court for more facts. And the university has filed a brief to say we want to have trial. So that suggests they have the evidence, they want to present it, so they have that full opportunity to support the validity of their program. Whereas Fisher wants it decided by the Fifth Circuit and wants to curtail that process. And so, and we know like Grutter, the university prevailed there, the University of Michigan, so they had sufficiency of evidence at trial to win. So in other words, in terms of transactional costs or administrative costs, to have that, to meet that evidentiary standard, it is a higher standard. But if universities had that information, they just, in this case in Fisher, didn't need to present it all, and that's why the court either did not or could not do their independent full assessment, and then it's just a matter of giving that forum for that information to come out. So I'm not sure that it necessarily provides disincentive when we know that state universities, flagship universities like University of Michigan, University of Texas, we know that other schools joined in supporting the university in their amicus briefs. That looks like state universities are very much invested in diversifying their student bodies.
This is a question for Professor Lee. One other thing we wrote about was Fisher is similar to Adarand Constructors case in the sense that Adarand looks specifically at the CSI prong. And likewise, I don't think we didn't really find a case before this that focused specifically on the narrow tailoring prong. How do you think Fisher would affect strict scrutiny in other instances?
Yeah, so we have Adarand and Croson, they deal with federal contractors, so it's not in the same context as Fisher or other affirmative action cases under Title VII. But in terms of what Fisher might say in those situations as well. To me, it suggests that the court is now looking for that evidence. So the court can look at that on their own and not have to give deference on that issue of the narrowly tailored prong. They don't have to give deference to the state actor, but they have all the evidence that the state actor can present for the court to determine whether that standard is met. And so it seems to me that for federal contractors who are looking to take into account race in carrying out those government contracts, or again for private employers who are not governed by the Constitution, but I still think we don't know where the Supreme Court is headed. I didn't get a chance to mention Ricci in my presentation. And Ricci is not an affirmative action case, but it's a Title VII case that imports a constitutional standard into Title VII analysis. So that's an additional clue as to where the Supreme Court might be headed. So in a post-Fisher, post-Ricci world, that perhaps all actors who are interested in affirmative action efforts to really bolster their use, should it come to a head in court, is to be able to be prepared to meet a more strict evidentiary standard. That really this was the best way to achieve their diversity goals, to take into account race, and that there was no feasible alternative, and they have the evidence to show that.
Professor Lee and I have a couple of things in common. In addition to this new courtroom, she's the chair of the Labor and Employment Law section of the Association of American Law Schools. That was a position I was happy to hold about 20 plus years ago. And then I've also been the chair of the Employment Discrimination section. And at the time, mid-1990s, the American Bar Association was sued by the U.S. Department of Justice, saying that the American Bar Association did not have as much power as it thought it ought to have over the accreditation of U.S. law schools. And the great debate that I was able to set up was Bill Gould at Stanford Law School, facing off to Richard Epstein, the great law and economics scholar from the years of Chicago now at NYU. So I wish you a great good fortune in guiding the labor and employment law professors through the maze of what is probably the most interesting time by far in the last 50 years in American legal education.
Thank you.
We also share at least memories of a former dean, Reedy Hassel, who was the dean from 1990 until 1997. And at Thomas Jefferson Law School, they found when they were expanding the building, mastodon bones, a nearly perfect fossil, a gigantic fossil. And there were lots of pictures in various legal publications. I got a call from a friend of mine, a great legal historian, not a lawyer, which helps him see very clearly. He said, Dave, he said, can you tell the difference between the mastodon and the dean? And I said, I think so. And he said, well, I think the dean's the guy wearing the suit. Mastodon Central and the ALS is going better than that. Let me ask a legitimate question. What's the spin, if it goes back down to the Federal District Court, what's the Hopwood, shall we say, veneer on all of this?
You know, I think looking at the admissions process used by now, the University of Texas in the current iteration of its plan, and that it is a more individualized process. There's no quota or set-aside system to determine who gets in, looking at factors including race. So, it's this holistic review of the applicant, and everybody's assessed or compared against one another. No one is excluded from the consideration process for a seat at the University of Texas at Austin. So it seems to me that the way that UT Austin crafted its plan, and it's, in this time, understanding what would help make it valid, it seems, presents a better stage for them if it goes back to federal district court to be able to show that their program is narrowly tailored to support to meet as asserted goal of having student body diversity. So I think I think that Hopwood shouldn't, hopefully, pose a problem, but that it can prevail on the merits of how it is implemented now.
Back in the early stages of working on this, Brendan here sent me a memo saying, this case could be a dud. It looks like a dud. The real question is, why are we writing about a dud case? And so we get into Brandesian abstention theory and et cetera, et cetera, et cetera. But why was Brendan probably right? Why was this a dud? And don't we have a great deal of audacity standing up here talking about a case that may be in fact a dud? And I learned great things from Rudy Haskell, by the way, when he had the game plan for this great building expansion. He was a very detail-oriented guy. And he would say, Gregory, this kaleidoscopic sort of weirdness, where's it going? I said, I don't know, that's why it's kaleidoscopic weirdness. But he was a very procedurally oriented fellow, and I learned a lot from him. So why or why not is this case a dud?
Well, I would love to hear, since that was Brendan's turn,
Right.
perhaps you can elaborate.
Well, we watched the case last May. We waited for the opinion to come out. It took forever. Came out in the last week of the term. And everyone kind of thought it was going to be a sexy game changer kind of case for equal protection jurisprudence, and really wasn't. It was very terse. It was overly legal. It didn't make the front page in the New York Times in the way that other Supreme Court cases hit the press. However, we then started looking at Shuett, and again, we've been waiting for the opinion in the Shuett case. We don't know whether or not it's going to be a game changer. I think part of writing in academia and writing in these kind of law review articles, you really want a game changer because it makes for the most interesting sort of paper. But as our other panelists mentioned at 1:30, this is reality. Sometimes some cases go certain ways because that's legally how it should follow. So if Shuett comes down and it's contentious and it's well reported, that will be interesting for the legal academic community to look at it. But we've been looking forward to Shuett also, and actually it would be great for Professor Lee to give us her thoughts on that case.
Yeah, so I haven't been following Shuett as closely as I have been for Fisher, so I don't know if I'm the best commentator on that case, but I agree that that's the next step in the series of cases that the Supreme Court is looking at with respect to affirmative action in the university setting. So I do think it has that potential to add a bit more to the discussion. And I see your point about Fisher is not fully maybe what we were expecting. That may not be such a bad thing when we're talking about a hot button issue like affirmative action, and the Supreme Court, they say a bit too much right now. It could be, maybe saying too much in terms of the future of affirmative action, whereas kind of right now they're clarifying, the court's review, the judicial review standard, and keeping it procedural. Yes, not going to the merits of the case. I think the whole idea is that that's what the lower court should have done. So it would be premature, or it's not right for the Supreme Court to weigh in on that on the merits when that wasn't fully done in the court below. So they're dipping their toe in the debate, but only deciding it for the purpose of sending it back to the lower courts. So that cautious approach, I don't know if it's a bad one, given that they think more facts need to be presented. But perhaps if I could also throw out a question, given that we have student panelists here, and you're attending school, in this current era where we're having these cases with respect to affirmative action and the importance of having student body diversity and how it contributes to your learning experience, or lack thereof takes away from your learning experience, whether you're a majority group student or a minority group student. How is it for you in your experience, in an educational setting right now from a student's perspective, how this issue, really matters on a day-to-day basis, in terms of your learning or what you see with yourself or your classmates, and why, how does that affect our understanding of the importance of affirmative action?
I could take that one. So obviously I'm a woman, and thus affirmative action has benefited me greatly. I mean, 50 years ago, I probably wouldn't have been sitting up here or been in law school or gone to college. So there's that. But beyond that, the diversity of my undergraduate institution and at St. John's, I think, has really benefited me. And I hope that my views benefit other people in just getting a more collaborative learning experience. And when we have discussions in class, constitutional law comes to mind as one of them. Just hearing people's different opinions, and you know that it's shaped by the way where they grew up, where they're from. I think it adds something invaluable, and I would hate to see a case like Fisher discourage schools or programs in general from trying to create that environment, because it really enriches people's learning experiences like nothing else does. There's no point in sitting in a room where everyone has the same opinion and just saying, yeah, we're right, that's so great. Like, I would like to hear from other people and disagree with them and, you know, expand my viewpoint like I hope I've expanded theirs.
Okay, so in addition to Sarah, I also agree that it's undeniable that diversity is critical for a vibrant learning experience. I think that diverse students will bring in unique perspectives, opinions, and experiences, and people are able to bounce ideas off of each other, and everyone's able to grow from that. Another thing I think that is important with diversity is, so in our paper, I don't think we brought this up yet, we talked about how important it was for people to have access to degrees, because in order to get jobs and professions, you need a degree, it's a prerequisite. So I think that diversity helps because it leads to more diversity in universities leads to diversity in workforces, and when there's diversity in workforces, people are able to think outside the box. And I think before one of the panelists said that diversity was something that businesses looked for because it increased ideas and led to, I don't know, I guess more interesting or better business practices, because you have all different people posing all different ideas. So I think that diversity is important not only in school, but since it leads to diversity in the workforce, it's also important for that reason.
I'll speak as the majority member, the white male. But Miss Berrien, who spoke at lunch, she was wonderful to hear her speak, and she was talking about the importance of Catholic education. She got 12 years of a Catholic education, and so did I. I've only been educated by two different groups, the state of New York and the Catholic Church, and I attended an all-boys Catholic high school, so I had a different experience growing up. I eventually went to college. I went to a state school that was large and diverse. But to echo what Sarah said, you know, and really at this point in professional school, to prepare you to go out to, if you're in law school, you have to be prepared to, you know, be in the courts, and you're going to deal with a wide range of people, judges, opposing counsel, clients, and, you know, St. John's does have, I believe, a truly diverse student body, and not even that, I'm also in the night program with many people here today. And I've had the chance to meet people who come from different backgrounds, teachers, police, firefighters, you know, people who I wouldn't normally interact with. And it is definitely, it's of the utmost importance that at this point in my career that I am interacting with them in the classroom.
St. John's University several years ago was faced with a couple of choices. As Yogi Berra said, when you see that fork in the road, take it. And I'm proud to say that St. John's Board of Trustees made a very firm commitment that at the college entry level, they would accept at least 40% of the applicants who are at or below the poverty levels. Now, that's a huge commitment, but with a risk of fairly high attrition, every once in a while you hit a Mario Cuomo in the rough, a Ron Brown in the rough, etc. And so St. John's, realizing that the poor, as Jesus said, are always with us, and yet the Catholic Church's preferential option for the poor, St. John's made a great, great and noble commitment. It's difficult, we're getting there, and I predict in the next 10 years, the complexion of these sorts of panels at this law school are going to be very, very different. Sometimes the violence of the law, when it's directed like a laser, it can be a very good thing and lead to very fine results. As I tell any student, given my own experience, the one course you wanted to take in law school and didn't get to, in the real world, that'll be your first case. And when you have no idea what's going on, think about the haves and have-nots, think about who has it, who wants it, how it's going to be kept or concealed or revealed, ultimate truth being revealed. And the tangible way we figure that out in the real world is follow the cash. A great song by Berry Gordy, updated by the Kay Giles Band. First I Look at the Purse, the great Contour song out of Detroit in the early 60s. Follow the money. And what we try to do, what these great students try to do, is figure out what did this cost the University of Texas on an annualized basis. And despite their best efforts, we couldn't pin a real number. There's a huge bureaucracy. And Brendan, again, there's a lot of common sense at St. John's. Maybe not as much in my case, but the students have great common sense. And we all sort of were puzzled because we couldn't figure out exactly how much money was on the table. It's in the multi-millions. And then the open question is, could the money be spent in a more just way for a more just result?
Yeah, what Professor Gregory is alluding to is that the one concept we had is we worked with was instead of, Professor Lee challenged the point about whether or not it raises operating costs, whether the Fisher opinion raised the operating costs for an affirmative action plan. Let's assume for a minute that it does. Would diversity be better served by using that cost to provide more scholarships to diverse students? And that's a question. I think that's more of a policy point. If affirmative action wasn't permissible, if it wasn't a compelling state interest, then it would be necessary for a school who wanted a diverse environment to go down that route. I think at this point, the fact that classroom diversity is a compelling state interest has been settled. And I think that's actually one of the important things about Fisher is that it was a 7-1 opinion reaffirming Grutter, which was a 5-4 decision, that classroom diversity is a compelling state interest, making it harder in the future for the court to backtrack on that. So in that way, maybe affirmative action is a little more entrenched in society now, especially.
Yeah, no, I think that's a great point that Grutter was like you said, a more divided case versus the Fisher decision. So not only does it affirm Grutter, which was a little bit more precarious, but as you say now, it strengthens it with the majority of the court deciding in its favor. And as I think about the administrative costs for state actors or state universities to then meet the strict scrutiny standard with respect to the narrowly tailored prong that the student panelists are pointing out in their research, and that's an empirical question as to whether it does increase those expenses for state actors that might then present a disincentive. So not only is it a stricter legal hurdle, but just financially it may be harder for them to finance. And it very well may be that the court did that thinking it could raise those costs on a practical level so that universities may have to think a little bit harder about how to spend their funds. And maybe that's part of the court's desire without saying so, to make it less, to try to phase out, right? Trying to phase out the use of race in admissions policies at state universities, but without coming down on it in that way, kind of doing it by making the standard more stringent. We know that we have current members of the court. Professor Martin mentioned before about the Seattle case. The Chief Justice John Roberts made that point about the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. So we certainly have members of the Supreme Court in its current makeup, not welcoming the idea of continued use of race, that they think to really get to that end point, whether 25 years from now, or I guess less than that, according to Justice O'Connor's estimate, that we have to actually stop using race. Otherwise, we can make that aspiration, but how can we get there if we continue to use race? So, towards that goal, get to a point where race no longer has to be used, and maybe the court is trying to get us there in less indirect ways. But I think that is an interesting question, whether that might be one of their, their motives or interests in presenting the Fisher decision as they did.
You have a few minutes for questions. Ask us anything, except tomorrow's lottery. No. So anybody. The timekeeper fast approaches. Professor Baines is in charge of our collective destiny up here, and so we can do Q&A until he says otherwise.
I think they took back the microphone, so
for good reason.
Ask a question and speak loudly.
I got a question.
Speak loudly.
It's for David. Do you think that the analysis of strict scrutiny would be any different? I mean, if it's race-based, if it's sex-based, if it's national origin-based, what if an employer wants to have homosexuality-based, for example, affirmative action plan? Does the analysis in Fisher change based upon the notion of the protected characteristic?
Absolutely. I think that was one of the more important points made during the day, that the political, economic, sociological power base in this country is built on, over black male successors who lived 7 or 8 generations ago in abject slavery. Those folks are still at or near the bottom in almost every measurable category of normative success. And Caroline Product's footnote 4 in 1938 clearly was talking about race. When they're talking about discrete and insular minorities, it was clearly race-based. Everybody else has climbed on board, and they've accelerated past the descendants of the slave in the agrarian South. They're even eclipsed, or especially eclipsed, by international elites, not African Americans, Africans, who are multimillionaires getting increasing percentages of the degrees at the Ivy colleges. So I think we need very much to consider who was the original target beneficiary, rightly so, of strict scrutiny. And clearly, I recognize that other interest groups can certainly make valid claims, but the most compelling claim is the black male in the agrarian South still at or near the bottom in all measurable categories. And that is something that was most brought home to me recently as a 60-year-old white guy, to see that remarkable movie, 12 Years as a Slave. The micro psychosis of that clearly confirms Bob Cover's view that the law is a dangerous thing, it's a violent thing, and the law, the legal regime, turned a blind eye. And how many hundreds of thousands of situations like that over the years, nobody really knows. And it's the descendants of that man who should be the primary beneficiaries of a very carefully calibrated affirmative action plan or strict scrutiny in almost any context I can think of.
Yeah, but does the legal analysis change? When you're trying to look at something narrowly tailored, does the legal analysis change? For example, if you have an employer in New York and homosexuals have been discriminated against, and there's horrible stories about them, as well. Does the legal analysis change if you're dealing with something that's race-based, or if you're dealing with something that's not race-based? Or does the legal analysis have to be the same?
I'm not sure. I'll have to think about it.
You're equating race with homosexuality. You think they're analogous?
No. I mean, I'll just give you an example. I mean, but for example, Title VII protects. You could have an affirmative action plan based on gender. Okay, and when you're looking to survive strict scrutiny, does it matter if it's based on gender? Does it matter if it's based on
but you don't. But the court uses different standards based on the category. And so for gender or sex, it's intermediate scrutiny. For race, it's strict scrutiny. For anything else, it's some sort of rational basis test. And this is sort of the complexity of affirmative action, though, because that means that with affirmative action, because the court now has said all race-based, quote-unquote, discrimination, whether it is positive or negative discrimination is used as strict scrutiny, it means it's hard to discriminate for or against people.
But that was in the context of affirmative action. So my question is, I agree, is that sex-based is usually intermediate scrutiny.
Sex-based
So
would also be
you saying that
intermediate.
if you have a
Sex-based
sex-based
would also
affirmative
be-
action plan under Fisher, it would be intermediate.
Sex
scrutiny
would
as
also
well.
be intermediate.
With an affirmative action.
With affirmative action. But what ends up happening in terms with government, and I've worked on a lot of this at the FCC, is that they will treat all of it the same because of the divisiveness that it breaks, with the different communities. And so it will treat both, if they're going to have an affirmative action program for race or for sex, they'll treat it all under the same standard. Because otherwise, you may have, the complexity here is you may be able to have an affirmative action program more easily for LGBT, for instance, because that's lower standing than you could for sex or for race. Because this is sort of how the court has designed this sort of thing, but it's not because, part of it is because we're not there yet with respect to equality with a lot of these different groups, right? So the chances of actually having an affirmative action program, let's say for LGBT, is probably less so, because the court, saying that you can rationally discriminate sometimes against it. So that's, I think, the complexity of it.
I think we're to close. Professor Baines, tell us what's going to happen tomorrow and when.
Thank you, David. This was a wonderful panel. Let's give them a warm round of applause. And I want to particularly thank the students who I thought were wonderful. This is an example of how wonderful and smart and talented and articulate our students are. So let's give them another round of applause. And let's also thank Professor Lee for her participation in 2 panels back to back. She was really, we overexerted her today. And so tomorrow, it's with great pleasure that I'm the co-chair of this with David. It's been wonderful working with David. David really thinks outside the box, and that's he's a brilliant, intelligent colleague, and he really thinks in very different ways, and it's really great working with him in terms of thinking about these different ideas and working on things together. And so today was at St. John's, tomorrow is at NYU Law School. It'll be starting at 10, it'll be 10 to 5 at NYU, so I hope all of you can come to that. And David asked me to do a close, and Stephanie's going to close also after me. So let me do a few things in the closing. I've taken notes during the day, but the first thing I didn't get a chance to do earlier is that Senator Gillibrand sent us greetings for the conference. And let me read her greetings for us. She's a U.S. Senator, for those who may not know, from New York, for those who may be from out of town. And she says, it's a privilege to send greetings to everyone attending the 50th anniversary celebration of Title VII of the Civil Rights Act of 1964, hosted by St. John's University and New York University. Today we recognize a monumental passage of the Civil Rights Act of 1964. This profound milestone in our nation's history shows our continued dedication and commitment to reaching the goal of every man and woman being treated with respect, dignity, and equality they deserve. I am grateful to the law schools of St. John's University and New York University for continuing the legacy of activists like Dr. Martin Luther King, Jr. It is my hope that your efforts inspire others to take part in actions large and small, public and private, to enhance the well-being of those in our nation. I send my best wishes for a wonderful event and many more years of continued success. Sincerely, Kirsten Gillibrand, United States Senator. So that was very, very wonderful remarks from, greetings from Senator Gillibrand. And I think that what the day meant to me, and it's something that I sometimes don't think about, is how important Title VII is for all of us, for me personally. And sometimes I think also, as we see from the panel, I think Sarah was talked about this very eloquently, for all of us. It's really important for us to think about what this room would look like 50 years ago. 50 years ago, who would be in this room? And what kind of conversations would you be having 50 years ago? It would be a very, very different conversation. You may not be having this conversation at all. And so it's really, really important to think about what Title VII has done in the civil rights movement, the civil rights struggle have done for us. And I saw this specifically with the first panel, where we had lived history of many of the panelists. Because one of the things is growing up in the North and not having family in the South is that one of the things that struck me is when I would meet people sort of my age or so who grew up in the South, who actually went to segregated de jure schooling system. And I would say, how's that possible? I mean, you don't really think about it. You think of it sort of as a historical oddity to some extent. And you think of Condoleezza Rice. I think of Condoleezza Rice, who I think grew up in Alabama, if you may remember, and she was the same age as those 4 little girls who were killed in that bombing. She was friends with them. She knew them. And went on to be the first African-American woman who was Secretary of State. So think about what the promise of her friends who were brutalized and killed because of that struggle back there, the promise that they could have been what Condoleezza Rice was and is in terms of her contributions to our society and her being a role model with respect to being the first African-American Secretary of State. So it's really important to keep that in mind, that even though it seems as though we may have made much progress, especially with young people who may not necessarily recognize how recent all of that may be, because these are people who are alive today who have experienced that kind of discrimination in their past. And also think about it from the standpoint, we've had that representation this morning, but think about the ones who are on the other side, who were not talking about the privileges they had, who may have grown up in the South, who were in the segregated schools, but the white segregated schools, and what it means for them who are really maybe just in their 50s today, who might be leaders. They obviously were impacted by this as well. And so I think it's really important to keep all that in mind, is that yes, there's been a great deal of progress, but there's still a long way to go, and we've seen that with a lot of the panels today and a lot of the commentaries, the testimonies, etc. So I'm really pleased that you're all here. I want to thank you all for coming. I think it's been a great day. It's great for the Ron Brown Center to co-sponsor this event and be involved in the event. I'm so proud of Mr. Carter for winning the award. And let's give him another round of applause. Because the other thing I may not have mentioned, or maybe I did, but his paper was doubly honored. You know, the journal itself was found to be the best paper for his class. So I'm very, very happy for him. And it was so apt to this in terms of looking at sort of modern issues with respect to discrimination. So that's enough for me now. I will see you again tomorrow, and I want to turn it over to Stephanie to say the final farewell and goodbye for today, but not for tomorrow. Thank you.
Good afternoon, honored guest, accomplished panelists, and the St. John's community. Today we've heard a rousing historical commentary and heard some of the personal effects Title VII has had on some of our own panelists. However, as today's discussions continued, we've heard from panelists how Title VII has made strides, but still continues to be developed even 50 years after it has initially been passed. And no matter what Wikipedia says, there is still discrimination that needs to be dealt with, to echo Dean Simons's earlier comments if you were here for the first panel. I would like to personally thank everyone that my co-symposium editor, who, as we all know, had a baby 8 days ago, so she excused herself a little while ago, so. This symposium would never have happened without the dedication and vision of Professors Baines and Gregory. Their talent for scoping out the greatest panelists is unfounded, and we would never have had the caliber of speakers without their efforts. So I want to thank them. And I'd also like to thank all the behind-the-scenes players that we thanked earlier today. As you saw, today went off without any hitches. So Paula Edwards, Kristen Giuseppe Ferguson, Maureen Mulligan, and everyone else from the administration of St. John's. And on one more personal note, I would like to thank the Journal of Civil Rights and Economic Development's second-year staffers who so diligently kept time and worked at the registration tables today and worked to make sure that your CLE papers were filled out. If you could just bring them out to the desk as you exit so that we can make sure that you get all the CLE credits you deserve. As you know, tomorrow the symposium continues, and I hope to see all of you at NYU tomorrow morning at 10 a.m. Thank you.